Good morning, ladies and gentlemen. Good morning. Good morning. Happy Monday. Happy Monday. In just a few minutes, the continuation of the Young Thug trial will commence. And I will be giving commentary throughout the trial. I'll be bouncing in and out of the courtroom. But we're going to start covering the live trial from our desk. And at some points, depending upon what witness is testifying, I'm going to step my butt inside the courtroom. With that said, I hope everyone's having a good day. I know just starting out, first day of the week. Put a one in the chat if you can hear me, ladies and gentlemen. Put a one in the chat. Put a one in the chat. You know how we do it. We warm up the room. We get it popping. This is hip hop, and this is a trial involving a rapper that is well respected in the Atlanta community as well as abroad. And the prosecutors is trying to say that Jeffrey Williams was a part of a organized street gang that committed criminal acts. Well, we're going to look at the witness testimony. As you guys remember, I showed one of the last witnesses provided testimony, but he really didn't provide anything. He didn't remember. He didn't have any recollection as to the interview he did with veteran detective, one of the most respected detectives in Atlanta. He didn't remember anything he said to this detective. Nothing. And this is going to be interesting today. Let's see how the line of questioning continues. Let's see whether or not he has gained his memory since the weekend. He's not under indictment, ladies and gentlemen, so he's done time as well as it related to some of the incidents dated back to 2011, 2013. But we'll see. We'll see. I'm glad you guys are joining us today. We're going to keep this conversation going, and we're going to be bringing in legal analysts to discuss the testimony. So we're going to have some fun today, ladies and gentlemen, and we're going to be bringing in other members of the hip hop community throughout the trial coverage as we listen to testimony, and we want to get their take on it. So we want to put a different spin on it, and I don't think you guys had the benefit of watching us in real time cover this story. With that said, I invite those who are interested in the discussion. I will also provide a link during the break for other individuals who may want to offer some commentary on this subject matter. But the only thing we have right now is that you don't troll and you have a camera. With that said, ladies and gentlemen, we're standing by waiting for the judge to take the bench. When the judge take the bench, we will bring you inside the courtroom. With that said, let me see what people are saying. Let's see what people are saying. I see my good friend Vanderveer. You know something that the other platforms don't do? They don't really shout out the loyal supporters. I'm going to do that today. I'm going to be shouting out the loyal supporters who have been following both Hip Hop Enquirer as well as Mr. Dennis Byron's page throughout my illustrious YouTube career. I haven't been on YouTube a long time, but I've been in these hip hop streets for a very long time. And with that said, we're going to look at some of the testimony and we're going to do an analysis on some of the witnesses. And let's see who is really telling the truth and who is capping. Who is capping in this very high stakes trial? We want to know. Appreciate you, ladies and gentlemen. What did you guys think about the coverage of the before the judge takes the bench? What do you guys think about the coverage of the Nature Boy trial? What do you think about the outcome? Because that was a very intense, very disturbing trial. And it had so many twists and turns. It had so much antics. It had so much COVID. But at the end of the day, I'm here to talk about it. I didn't reappear in the court after we got that information, but I'm here today. With that said, ladies and gentlemen, I would love you guys to provide your thoughts on that coverage. And do you want to see more live coverage throughout certain type of trials? And if so, let us know what trial you really want us to cover as it relates to the culture of hip hop. Something that will spark the interest of the community. I want to know. I want to know if you want me on the West Coast, the East Coast, the South, or out the country. Where you want me at? I don't know about out the country. I don't think that's going to work for me. But ladies and gentlemen, I appreciate you. I really do. We're gonna wait until the judge takes the bench. With that said, stand by, stand by, stand by. We are going to be pulling the camera in shortly. I'm sitting in my own makeshift courtroom. You see that clock behind me? Okay, you know what it is. You know what it is. Yes, ASAP Rocky. We're going to be covering ASAP Rocky. He's from New York. He's from New York. Unfortunately, he's been charged with the crime in Los Angeles. There are a lot of people that have interest in this case, not just because he's a well-known hip hop figure, but he's also dating one of the biggest names in music, Rihanna, and they want to see if Rihanna's going to pull up. Me, I don't think she's going to pull up every day because she's taking care of children. Well, how many children does Rihanna have? She has one or two. I think she has. Does she have two children now? One. I can't keep up. Babies all over the place. Wait, let's listen. I ain't mad at ASAP Rocky. He got a good one there. Everyone else had, not everyone else. Some people had the opportunity to be with Rihanna for a long period of time, but they blew it. You know, they blew it. They let the Bayesian beauty go. And with that said, ASAP, he stepped up. I ain't mad at him. I'm not really mad. She has two. Wait a minute, hold on. She has two boys. Oh no, Rihanna. Listen, Rihanna ain't trying to. I don't know. Two boys and another one in the oven. Shout out to ASAP Rocky for putting that work in. Boy. Oh my goodness, three babies. She don't really need to work. Let's be honest. Do Rihanna really need to work in the music anymore? She has the beauty line. I mean, she's a billionaire. Arguably, she's a billionaire right now. She don't really need to make more music. She's just doing that for fun. Because the music itself is cool and everything. Unless she wants to be on tour and do all that stuff. But I don't know if that's going to be doable. Unless she wants to, she got a bunch of nannies around. But I don't know about having nannies raising the kids. I didn't have a nanny growing up. We didn't have nannies in the projects. We had nosy neighbors. You know what I'm talking about. We had nosy neighbors. But anyway, they looked out for us. They really looked out for us. All right, guys, let me okay. Now people have been asking me about Puff the Dipster Diddy. Will I be covering if his case goes to court, would I cover it? Absolutely. I've covered Diddy's first trial in New York years ago. I covered that trial. When a lot of you wasn't even thinking about trial coverage, you were just sitting there wondering when's the next party. I was in the courtroom covering Diddy. When Diddy was on trial with rapper Shine, I covered that trial in New York. And I met some cool people covering that trial. One great guy I met, it was a martial arts colleague, uh, Glenn Beck. Glenn Beck was security for Puffy, but he became a very good friend of mine after the trial. We had mutual friends. Look him up. He's a really great guy. I've actually met Glenn prior to the trial. I want to say I had a big photo shoot in New York at the 4040 Club, and because of who the artist was, we had security there. And I believe Glenn dispatched one of his guys, but I think I met him back then. But let me just say this: I will be covering Diddy's. Whatever it is, I'm covering Diddy. I've covered Diddy before he had any trouble. I covered Diddy back when Diddy was probably right after him leaving college. Well, dropping out of college, but I covered him for a while. Okay, so Vlad, excuse me, Vanderveer. Yeah, that was an interesting case. I see a comment. I see a comment. Listen, before we got to handle some business first and foremost. We got to handle some business first and foremost. Let me go ahead and drop the banner in so we know how to show the love on this platform. We're going to put that banner up there right there. You know what that banner is about? That's about the business. We're going to remove that banner for a quick second, and we want to put this one on real quickly. Hold on, let's go. This is the banner here, ladies and gentlemen. That's the banner. That's the banner. That's the banner. Make sure you are following, subscribing, liking, sharing, caring, and let's keep it going. Okay, hold on, Vlad. I'm jacking your name up. Hold on. There are cases that I will cover, and there's some that I don't have an interest in covering um, more so than the ones that are really necessary for me to cover. Not to say that there are not other journalists who could cover those cases, like Court TV, um, Law and Crime. They can cover those cases. Certain cases, no, no, no. I'm going to stay within the wheelhouse of what I do and type of cases I cover. I cover a lot of cases. It just has to have that it factor, if you know what I mean. I think Vanderveer, I think you're right. I think I should bring that case back. Only for referencing what was going on during that time. Because a lot of you don't remember the case or probably don't never heard of the case, but it was a big case. And if you're over 30, 40, you remember the case. Maybe you're about 40, you remember the case. But definitely if you're 30, you probably remember that case. That was a big case. It was it you know it got shined 10 years. It got shined 10 years, and Puff was able to avoid any jail time. He was acquitted. It involved Jennifer Lopez. She did. Well, the case didn't involve Jennifer Lopez, but the circumstances surrounding the case did. Uh, and she cut ties with Puffy right afterwards. She knew when. Listen, that might have been a smart thing. If now that we look at things, she cut ties with Puffy back then. I asked the question on Twitter: who is still trying to party with Diddy? Who is still trying to party with Diddy? Is Diddy's career over? Is there too much out there that people want to hang with Diddy still? Because Diddy definitely had some of the biggest parties, the best parties. He had the clubs popping back in the 90s. He had the clubs popping. He had the streets hot. He had the clothing line, Sean John, Ciroc. He is the mega mogul. Let's not play with the guy's name more than he's played with his own name. But my point is, he had the streets on lock. He was the face of hip hop more so than anyone else. I mean, he's in the videos. He done brought some of the biggest stars out. Come on, Mary J. Blige, Lil Kim. Come on, let's Faith Evans. Let's talk about it. Uptown Records. Come on, Bad Boy Records. I don't know if he's out of here right now. I don't think he's out of here right now because he has tenacity to persevere. But these cases are looking a little crazy. And it all started after the lawsuit involving the liquor brand. Not to say the two are connected, but it's quite interesting that it all started coming down after that. Listen, listen. I ain't gonna lie now. I've been in a few Diddy's parties, but not the. I didn't get the VIP come to the boom boom room party, and I'm good on that. No cameras allowed. You could come in and get the shot. I got some of the craziest shots from back then. You know, and don't play. A lot of you guys were supporting Diddy. You're still supporting Diddy. So don't listen. First of all, he has not been found guilty of anything other than paying that high amount of money to Cassie to settle the lawsuit. But uh, no other criminal charges have been filed yet. So we have to see. We have to see. I don't know. We got to see. We got to see if this is going to be a problem for him. He has some great lawyers, but these lawsuits are just names are coming out left and right. Wait a minute. What did Stevie J do? We got to see. Right. Puffy was the protege of Andre Harrell. Absolutely. Absolutely. And they end up giving Andre Harrell a job. I've interviewed Andre. I've interviewed a lot of people from Bad Boy over the years, but I rock with the other label. Heavy, heavy. Rough Riders. I rocked with Rough Riders, but I had no problem with it. The rock. Let's not make no mistake. Puff had one of the best rosters in music, best shows, best stage performances. We're not going to just discredit what he brought to the culture. We're not going to do that. But we got to, at least from a journalistic perspective, investigate the story and see where the story goes. No different than I did back when he was on trial with Shine. It was a very high profile, newsworthy story. Very high profile, newsworthy story. So I haven't talked to D and Wah in a minute, but I was very cool with Siobhan, their sister. I talked to Wah probably in LA. I haven't seen D since the funeral. I haven't seen him since the funeral, DMX's funeral, to answer your question. Um, but I still talk to certain people that from back then. It's just we run into each other when we run into each other. This is the industry, you know. But last time I see anyone, uh, with the exception of Swiss Beats, was at DMX's funeral in New York, Brooklyn, New York. If funeral I covered. Uh, I also did business with DMX, and one day I'll tell you guys a story. Made a lot of money with DMX actually. And back then it was a lot of money. I did after parties, so I was the guy that wanted to get some of the after concert party money. So yes, to answer your question, you party with Cardi? Oh man, Stevie. See, there you go, Baltimore Shorty. There you go, Stevie. Oh man, I covered Stevie J's. I guess he had a federal case. It was in federal court, but he persevered in that. He persevered. If you Let me just say this: if you are out here in this industry, you're bound to catch a stray if you really outside. If you really outside and you want to be seen and you're bound to catch a stray. You're bound to catch a stray. I'm telling you, I almost caught a stray. I was at a club with Queen Latifah back in the day. Shots fired. Literal shots fired. I hit the floor. She hit the floor. Then we hit the door. I remember like it was yesterday. It was the Shadow in New York. Those who know New York know some of the New York club scenes. Know about the Shadow. Well, we ain't gonna share those. We ain't gonna share those stories. We're gonna leave that. Leave that. Leave that behind us. Listen, who's these they say? Who's the when people say they say, who are they? Who the they we talk about? Who's these they? I always wonder these days be saying they said this, they said that. Who are the they? Oh my goodness. Oh man. You would be surprised what some people's appetites are. You would be so surprised. I mean, crap. I was surprised that Jeffrey Dahmer's had his appetite. My my folks was watching the documentary on Netflix of Jeffrey Dahmer. I'm like, what are you watching this crap for? I don't want to watch this crap. But they were intrigued. She was intrigued. I'm like, what? Yeah, I don't know. We'll talk about that later. But she probably watching now. Okay. Uh, Farnsworth Bentley, interesting guy. I would just say that he's an interesting guy. He's an interesting guy. The whole walking around holding the umbrella over Puffy. I thought that was, now that I think about things, Farnsworth walking around with that umbrella back in the day over Puffy was different. It was different. It was very different. I wonder what he got paid for doing that. You know? Oh man. Oh my goodness. Maybe one day I'll get the backstory on that. And people have asked him. I last time I seen Farnsworth was probably at a revolt conference. But I should have asked him, "What's up, the umbrella, Playboy?" Oh yeah, he's definitely no, he's definitely got a wife and everything. Yeah, yeah. And it's entertainment. It was entertainment. It definitely got people talking. Puffy is a master marketeer. He's a master at the game of promotions. So listen, some of the things he did, it was just was shock and awe. Some of the things he did was shock and awe. But we have to see. All right, let's see what's happening in the court, ladies and gentlemen. We're going to be back once the court starts. Uh, we're just waiting. We're waiting. With that said, stand by.
Stand by, guys. Stand by.
If you can tell the jury, what do you remember about your first encounter with them?
When my first encounter, when I spoke to them, I explained the policy, that they could be injured and liability issue. One guy stepped down, and the other said, get back on your board.
So how many guys on hoverboards?
Two,
And you were explaining to them why they could not be on hoverboards?
yes,
And was that part of the law policy why they could not be on hoverboards?
yes, new liability issue.
And I believe you just said, I just want to clarify, that when you spoke to them, one person got off the hoverboard, the other remained on the hoverboard. You shake your head, then yes?
Yes,
And the one who stayed on the hoverboard, I believe your testimony was, he told the others to get back onto their hoverboard.
right.
Once that occurred, what, if anything, did you do as it relates to those two individuals still on their hoverboards?
I just kept explaining the policy.
And did they say anything to you as you kept on explaining their policy? Your policy.
They said they were leaving.
What was their demeanor?
They tore me. It's all right.
I'm sorry, say it one more time.
Toward me, it was okay.
Towards you, it was okay. Now, when they did not get off of their hoverboard, what did you do?
I called Mike, called Mr. May.
And why did you call Mr. Mack?
That boy his job. When I can't handle something, I call him,
When you can't do what?
handle something.
And when you say you can't handle something, what couldn't you handle with this particular incident?
Well, they kept riding, and I ain't gonna put my hand on nobody. So I called him, let him explain to him.
And were you able to reach Mr. Mack?
Yes,
And did Mr. May, what happened with Mr. Mack?
he asked for my location. He came to my location.
And what location were you at the time?
Champs,
And what type of store was Champs?
shoe store.
Any of those things, would it help refresh your memory as to how the witnesses identified the individual who made the threat about shooting someone?
I'm sorry, can you repeat?
Sure. Looking at the three statements, would it help refresh your memory as to how they identified the person who made the threat?
They identified the male who made the threat by looking at him and then speaking with the manager at Champs, and then the photos on the internet. That's how they identified exactly who he. The manager at Champs said that it was
Objection, hearsay.
Any of those things, would it help refresh your memory as to how the witnesses identified the individual who made the threat about shooting someone?
I'm sorry, can you repeat?
Sure. Looking at the three statements, would it help refresh your memory as to how they identified the person who made the threat?
They identified the male who made the threat by looking at him and then speaking with the manager at Champs, and then the photos on the internet. That's how they identified exactly who he. The manager at Champs said that it was.
Objection, hearsay.
Sustained objection.
With each of the individuals who wrote their statements, you have three witnesses. Did they indicate?
Okay, ladies and gentlemen.
It was only
Ladies
one
and gentlemen. 1, 2. The actual trial has yet to commence. This is footage that I shot when this officer was giving testimony. So what you're looking at is a officer testifying to an incident that involved one of the defendants. With that said, let's continue.
Any of those things, would it help refresh your memory as to how the witnesses identified the individual who made the threat about shooting someone?
I'm sorry, can you repeat?
Sure. Looking at the three statements, would it help refresh your memory as to how they identified the person who made the threat?
They identified the male who made the threat by looking at him and then speaking with the manager at Champs, and then the photos on the internet. That's how they identified exactly who he. The manager at Champs said that it was.
Objection, hearsay.
Sustained objection.
With each of the individuals who wrote their statements, you have three witnesses.
That might be right. That might be right, V. That might be right. But who am I to judge? Waiting for Judge Glanville to take the bench in real time.
On how it works. If you can tell her, what do you remember about your first encounter with them?
when my first encounter, when I spoke to him, I explained the policy that they could be injured and liability issue. One guy stepped down and others said, get back on your board.
So how many guys on harbor boards?
Two,
And you were explaining to them why they could not be on harbor boards?
yes,
And was that part of the law policy why they could not be on the harbor boards?
yes.
See, this was the witness that the state called. That he really didn't have a recollection. He actually came in. He was someone that the defense didn't really question him too much because he really didn't offer much. And you remember the prosecutor Adrian Love, and during our opening said that there are going to be some people that don't want to testify. There'll be others that will not recall what they said previously, and it seems like that's the case. So my question is, why even call them if they have no recollection? Why even call them? Why bring them to the court and put them in front of a jury? And that's a interesting strategy, but let's just see how it plays out. Right, 10 years old. A lot of the evidence is 10 years old. That's a very good point. 10 years old. Again, I think I have a good memory, but I hadn't really been asked about things 10 years ago. But I think that most people, especially if it has anything to do with trauma, they try to put it behind them. They don't really want to recall that. People put things in their short-term memory, and then they put things in their long-term memory. And it all depends on what is most important to them. For example, I guarantee you, most of you that are watching cannot remember 10 phone numbers of people that you call on the regular. You can't remember 10 phone numbers. There was a time when we had to remember multiple numbers. It was just so crazy back then where we had to remember 20, 30 numbers in our mind. We had to recall this. You had to know what numbers to call in the event you had an emergency. Now, I'm probably going to guess that most of you probably don't know all your family members' phone numbers, because I don't know my daughter's numbers by heart. None of them, actually. That's scary. But we have to see. We have to see. So the footage that you're watching is the footage that I actually shot. Um, I want to share some of it. But we're going to bring some more footage up until the court starts, because what's going on, Your Honor? Where you at? Let's see here. All right, guys, I'm going to get off screen and grab some more footage from the archive, and we'll see. So you did wait a minute. See, well, hold on. There was a time you could do this. You could call the operator. Listen, I need to break in this line. She's on the phone. I need to get in. You can't do that no more. Who are you going to call if you're trying to get it through someone's call? It's call waiting. Call waiting. That call waiting was a feature that they used to charge you for back in the day. It was a feature. Man, I need to get that call waiting. They would charge you for that. Just think now. The things that you paid for back then, it's free now. It's going to be a time when you don't even have to pay for internet. I'm waiting for that. We thought Joe Biden was going to give that to the American people, but he didn't. What did he really give to the American people? I don't have a student loan that needs to be paid back. Give me something. Give me something, President Biden. It's like you forget. It's like they forget the older people. Give me something. Right. Y'all know y'all know you used to pay for call forwarding and call waiting and three-way calling. But the young people don't remember that. They so spoiled. They got the iPhone. They walk around with the $1,200, $1,400 iPhone. Oh, we got the iPhone. Man, half of you don't know what the heck to do with the iPhone. It is a work, it's basically a pocket computer. I mean, if you really want to talk about some of the things back then, who remembers the Star Trek phone? The little flip phone. The little black flip phone, the 6600, 8600 model. I remember the models because I had them all. I had every high-tech phone there was from the beginning of cell phones. Even the big block brick phone that you carried on your shoulder. See, I'm telling my age. But it was a big, like, block phone that you carried on your shoulder. Thought you were the man walking around with the big block and talking on the phone. You couldn't put it in your pocket. You couldn't leave it in your car because they would break in your car, take the phone out. And it was a time when the phones were mounted in the car. You had your phone mounted in the car. You had literally you had your landline phones and then you had your phones mounted in the car. Now you just take everything, put in your pocket. You got a watch. Your watch is a phone. This is weird. Right. How about the beepers? How about the two-way? I think it was a MCI two-way pages where you had to beam your contact. Beam your contact. You literally had to stand in front of someone and say, "Hey, listen, send me your number," and they would beam it. You see people. It looked crazy. If you look at a shot of people beaming their phone numbers to other people, now everything's easy. Now there's an airdrop. It's beaming back there. Today's airdropping. Airdrop your contact. Airdrop this. Airdrop that. But you don't want to have that conversation. I talked to my kids about this. And Dad, stop it, Dad. They didn't have that stuff like that. What are you talking about? We sure did. And who had the phone, the shoe phone? How many of you had a shoe phone where you move the hill and you dial a number? Who had a shoe phone? How many of you had a shoe phone that you can call your family and friends? You take your shoe off and you pull the hill back and dial the number. How many of you had the shoe phone? I only know one person that had the shoe phone. Maxwell Smart. Listen, you talk about Google Pixel. We didn't have a Google Pixel. There was no such thing as a Google Pixel. All right, guys. I'm waiting for the judge to take the bench. He's yet to take the bench. Uh, I'm going to check and see what's going on because we're waiting, Yana. We are here waiting for you, sir. We are here waiting for you. With that said, ladies and gentlemen, please stand by.
Now in session, the Honorable Chief Judge Earl Glanville presiding. Court come to order.
All right, good morning, ladies and gentlemen. Please be seated.
Okay. Don't know who that is. Okay, Judge, I'm not sure if she's been here before. Another attorney out there.
All right, good morning, council's interested parties. We're on the record in the matter of the state of Georgia versus Cleef Adams et al. In 22 SC 183572. Mr. Stillwell, Mr. Botts, and Mr. Shard. Good morning, gentlemen. All right, Mr. Williams, Mr. Steele, Ms. Renard. Okay, good morning. All right, Mr. Kendrick and Mr. Weinstein, good morning. All right, Mr. Huey and Mr. Matthews Jr. and Senior, good morning. All right, Mr. Nichols and Mr. Lamar, actually Mr. Garner, I should say, good morning. All right. Mr. Ryan and Mr. E. Williams. Good morning. All right. Ms. Hilton, Mr. Atkins, Ms. Love, and Mr. Brown. Good morning. All right. Okay, Ms. Renard, who's that interloper sitting to your left? And why was I not told anything about other people in my courtroom, Mr. Steele?
And good morning to you, sir. Your Honor.
Oh, don't be trying to get over that, man. You're already in hot water. So who do I have the pleasure of now being with you?
Your Honor, sitting next to Mr. Ryan and Ms. Renard is Haley Haltwanger, Haltwanger. She is a second-year law student at Georgia State University. I've had the honor of working with Ms. Haltwanger approximately 2 years. She's a fabulous lawyer, representing the next generation of lawyers, and with the court's permission, we'd like her to sit at the table. Mr. Adams means no disrespect to the court or Mr. Williams or anyone. He is not going to be here today. He is actually in another court the week on a trial. So can never replace Mr. Adams. I'm not trying to do that, but with the court's permission, that is who is in your honor.
Okay. Mr. Williams, you okay with that? Okay. All right. Okay. All right. Mr. Bean outside?
Yes, sir.
He is, Your Honor. Before we get started, I'd just like to ask if the court would allow us an opportunity to look at some certifieds that Mr. Steele indicated he has. He indicated he would show us the certified on this. And the court came in right before he had an opportunity to do so. So before we bring Mr. Bean, could we just see a copy of the certified itself? He
Sure.
gave me a copy.
You all can look at those.
And Your Honor, would the court like for us to bring Mr. Bean in before I look at the certified?
No, why don't you accomplish that and then we can bring Mr. Bean in. I just want to make sure he was here, that was all.
Okay. And is it?
That's not exact.
Thank you, Your Honor. We have been able to look at a copy of the actual certified copy of 14 SC 130460. And based on information that Mr. Steele shared with me just now, I don't want to speak prematurely, but it appears that he also has some indictments that he intends to use. And I move in limine that the court preclude Mr. Steele from any attempts at impeachment or improperly introducing indictments that are not certified convictions of this witness or any other. Based on the information that he just gave me when I asked to see the certified copies of conviction, he has only given me one certified conviction for Adrian Bean, and that is for Fulton County Indictment 14 SC 130460.
Okay, so there's no argument about the certified, is that right?
Correct. There's
Okay,
no
all right.
argument about
And then what about the uncertified or or do we, is that what you're asking me to,
Yes,
or to pose or weigh in on?
yes, because I've just been told that Mr. Steele has copies of indictments. I don't know.
You have certified copies of those convictions, sir?
And good morning again. As I told the district attorney's office, there's certified copies of charges of an indictment, not convictions. I told the district attorney I was not planning on seeking to admit them now, but they may become ripe. What happened in two different cases, if you want to know, is Mr. Bean was charged, serious crimes, armed robbery. I may be a little off here, but armed robbery, trafficking, marijuana, something to that effect. And the cases were dead docketed. Under Ridley, which is RIDLEY versus state, it's 368 Georgia Appeal 481. Your Honor, that's 890 Southeast 2D 385, 2023 case.
Bless you.
C, the conviction of Mr. I have a but that's 157. Can I see 157C if you don't mind? Being certified. I mean, I approached the.
You may, sir. Steele Westlaw don't want to cooperate this morning, but that's all right. Go ahead, sir.
I have a hard copy. I only have one though.
That'd be great, thank you.
I apologize. I only have one
All right.
hard copy. Um, 481 is. May I approach, Your Honor?
You may, sir. Thank you.
May I, Your Honor?
You may.
Okay, so what the court in Ridley explains is that the confrontation clause, it's in the 8th paragraph, Your Honor, it's on page 2, and I've explained that to Mr. Brown of the state. The confrontation clause of the 6th Amendment guarantees to the accused the right to inquire about a witness's pending criminal charges in an effort to show that the witness has a possible bias, prejudice, or ulterior motive that may influence the witness's testimony. Whether the witness is testifying pursuant to a deal with the state is not crucial to the right to conduct such a cross-examination. And then, Your Honor, on the 2 items that I may not use, but that the state was inquiring about, and I just put them on notice of it. I gave them a thumb drive today, and I told them, is Seals, S-E-A-L-S versus state, 311, Georgia, 739. And it's in Division 3B, as in Barry Bravo, and specifically, Your Honor, if I may have the one copy, may I approach?
Yes.
Good morning, ladies and gentlemen. I am reporting
The
live
case is
from my
Seals.
courtroom.
That actually determined it. That's our case in Georgia that made this, that a dead docket case remains pending. So because the cases are dead docket, not null pros, they actually are pending with Mr. Bean, could be brought back on a live docket with the court's permission. The reason I said I gave it to the state, I just gave them everything. The reason I did that was in abundance of caution, that it came up and I felt needed to do it. So I wanted to be courteous, as you told me to do, and you told everyone to do. So that's why I did it. But as I told the state, I'm not really planning at this point to use them. They are older, Your Honor. I wouldn't be using them for impeachment. I think I'd be barred by the 10-year rule unless you made a finding that it was critical. But I can impeach with Mr. Bean with other convictions, so I can't really argue that it's, quote, critical to impeachment of this witness. I'm not saying the witness is not critical, but, you know, I have other manners and means to impeach him, I believe.
But he might open the door as to other things.
Exactly. And that's why I just did it at abundance of caution, but I'm not really there in my mind, but I just wanted to provide the state. I also gave them about 6 this morning. I gave them about a 10-minute interview that, you know, Honorable Investigator Jimmy Martin Jr., which is, it's really James, J-M-E-S, Martin Jr., and I did with Mr. Bean. It was Sunday, January 22 of 2023. And I will be using that for impeachment because, respectfully, I know it's a jury question, but I believe he was not straightforward on his testimony on direct last week. And it's also a prior inconsistent statement, but it also goes to trial testimony under oath, which can be impeached at all times. So I gave that to the state early this morning. It's only a 10-minute interview.
Your Honor, 2 things I want to point out. Mr. Steele has had apparently this interview since January 22nd of 2023, if I heard him correctly. He did just send it to us this morning at 6 o'clock. That part is okay. The part that is not is that he would have to confront and lay a foundation for the playing of any audio recording that is out of court. Any such recording is barred as hearsay under 24A801 unless there is a, unless he can establish, unless he can confront, unless he can somehow establish that there is an exception to the hearsay rule for that particular statement. Secondly, the indictments that he has given us copies of, I believe for no reason should be allowed because they are way more than 10 years old. They are from 2011. He has, in addition to the certified for 14 SC.
Don't think that's the issue. He's just bringing them to the attention of you and the court so that if your witness should open the door as to him, I would make some certain probably findings at that point in time.
Yes, Your Honor, I understand. I, of course, do not intend to inquire into the defense's strategy, but for the sake of arguing that somehow there is a reason that this witness would want to cooperate with the state, that is what Ridley is intended to stand for. They would be able to show through open cases a witness's reason for wanting to cooperate with the state. And again, I would argue that these three, 11SC, 06SC, and 13SC cases for which Mr. Steele provided us indictments this morning are not permissible under any of those circumstances. And I, before he even tenders or walks to the witness to attempt to show them or even mentions them in front of the jury, I would ask that the court require Mr. Steele to, at the very least, outside the presence of the jury, tell the court what he intends to use them for. Because otherwise, once the toothpaste is out of the tube with respect to some impermissible document or impermissible item he wishes the jury to know about, it's already out. So I would ask that the court preclude him from even mentioning, tendering, or asking the witness about any 11SC case, 06SC case, or 13SC case that he has given us a copy of an indictment of for any reason until he, outside the presence of the jury, tells the court for what reason he intends to try and introduce it. Because again, we would argue that it's impermissible. It would be, as he stated himself, it's not permissible impeachment evidence. It is over, they are all over 10 years old. They're all closed cases.
But, well, they're dead docketed, right?
Okay, that's fine.
They're dead these two cases are apparently on the dead docket, right?
So the
Yes or no?
11SC case and the 06SC case are either they're dismissed for all intents and purposes. But the point is, and the 13SC case, let me make clear, I believe that one is actually states 157C. I believe he was sentenced for that one. So as far as if this is the same one that we've already introduced, we have no objection to that being used. But the 11SC case and the 06SC case were dismissed against Mr. Bean well over 10 years ago. And
Okay, all right. Were they dismissed? How were they dismissed? Were
Right,
they placed
good question.
on the dead docket? Were they null pros?
we don't have
Where
a
there's a
certified
verdict?
copy of the file. So all that we have is a copy of an indictment with nothing more from the file from Mr. Steele.
So how do we know how it was resolved?
Because the copy of we don't know exactly how it was resolved
They need to
beyond
know.
what Mr. Steele has shown us, which is the indictment itself with the word as to Adrian Bean, the counts are placed on the dead docket in July 2011.
Okay, well, they're
And I
placed
don't
on the,
know.
just stop. If they're placed on the dead
Stop.
docket, that case still is technically open. It can be prosecuted. And that's what the case law seems to
The
indicate.
statute of limitations has run on these items.
Well, you
and
need
we
to close the
cannot-
case.
We've dead docketed it in 2011. We can't bring it back.
So then no
No, the
process.
statute of limitations is satisfied once the indictment is returned in open court by the grand jury. There's not a statute of limitations issue with a dead docket.
Right, no process.
Again, Your Honor, since Mr. Steele has indicated that this issue is not right, my only request of the court is that before
well-
Mr. Steele mentions it, he, at least outside the presence of the jury, tells the court for what purpose he intends to try.
Let me ask a question. Mr. Steele, do you have some basis to believe that the state has offered Mr. Bean a deal, or?
Right, what's
has
going on
indicated
here?
They're not going to take these these dismissed cases off of the dead docket, or what's your theory of how you might confront the witness?
He would, no, to answer your question directly, no.
Okay.
I don't have any reason, good faith belief that the state is saying it's coming off the dead docket, but under Ridley, RIDLEY, that's not the issue. That's exactly why I gave you the case. It goes to the state of mind of the witness who is testifying, and the jury makes that determination.
The state of mind as to how?
Because what
Really doesn't say that.
Yes, it does. If you
Where
look
in
at-
really does it say that?
If
Point
you
to the
started-
page. I want to
if
see
you
it.
Started the 8th paragraph, which I think is on the 2nd page, Your Honor, and then go to the 3rd page. And it says in the very top left-hand, I'm going by my memory, but top left-hand corner, it should say whether the witness is testifying pursuant to a deal with the state is not crucial. I'm going by my memory.
Yeah, you're,
To the
that's
right.
pretty close. Okay.
To the right to conduct such a cross-examination. So it's a pending charge. This isn't about a deal. This isn't about conviction of 10 years of age. I just, God willing, straight with the court. I'm just telling you, I understand that if it was a conviction, I wouldn't be able to use. I have other convictions for him, but they're over 10 years of age. I'm not trying to get those in because I don't think it's right to ask this honorable court to make a balancing test.
So you're saying he's still facing charges, and that's
Exactly.
what you want to ask him about?
Yeah, that's all that issue
Yeah,
is.
that's a good.
All right.
That's legitimate. If he believes that,
It has nothing to do.
if
with
he
the statute of
believes that, and
limitations.
he's sitting
Nothing
on the
to do
stand, then the no
with,
man may have
a
some
conviction. I
some
mean,
credence.
I don't know. I'm just doing what I think lawyers should do.
Absolutely.
Being straightforward.
Good job.
Your Honor, under 403, given that these are dead document charges from 2011.
Then no process all the charges that he's not looking at. No process them.
Or Mr. Williams has any good faith basis to argue that under Ridley, he should be allowed to introduce this 11SC case and this 06.
That's what Ridley seems to indicate, and it tells me under 403, it's an extraordinary remedy, which should only be used sparingly. So if he wants to ask him about, he's facing charges, he's technically still facing charges, and he would be permitted to do that.
Absolutely. Absolutely. Good ruling.
If it comes up, okay? So,
Yeah.
but
Yeah.
right now,
Bring it up.
I
That's
would let him do that.
that is
Well, with that being
significant.
said, then I will do it.
Your Honor,
Yeah.
the court says that he is facing charges.
Ah.
He's still facing charges. He's got a dead docket. Dead docket stops the statute of limitations. It's still open case. How many employments times have witnesses or other people faced dead dockets, and then because the same thing, because it's still an open case?
Right. Come on, prosecutor Love. Come on, stop playing with the court. Stop
That's my
playing.
ruling. Can we move on?
Let's go.
Okay, all right. If it comes down to it, so, yeah.
It's coming.
He's got a good faith basis, so.
Good faith
If
basis.
it comes down to it, he can ask those questions.
Yes.
All right, anything else?
Not on behalf of Mr. Williams.
Okay, all right. Sergeant Ingram, can you summon our jurors for us, please?
Yeah. So what just happened here, and I'm not saying Prosecutor Love was trying to put a fast one on the court, but if you have a dead docketed case on a witness is on the stand,
Your Honor,
No.
Mr. Steele will not be attempting to play any hearsay. He will be tendering any,
Hold on.
my understanding, without laying any foundation for that. Right.
so Steele was right. You got a witness on the stand that may have an incentive to not answer any questions. He has dead docketed cases that is in the prosecution's office. They must be nolle pros, meaning they must be dismissed for him to be able to come in and speak willing and openly and willingly. So Steele is right by bringing that to the attention of the court. And Ripley says, if the case is still open by way of a dead docket.
All right, ladies and gentlemen, please be seated.
Come on. Come.
All right, thank you,
This-
Sergeant Ingram.
This is a chess move, ladies and
All
gentlemen.
right, ladies and gentlemen, good morning. All right, you sound good. Okay, all right. Ms. Love, I believe that we still had Mr. Bean with us, so can we summon him, please?
Yes, ma'am.
All right.
Yes, sir. Yes, ma'am. All right, guys. I'm gonna be in the background. You can ask your questions. We want the full
Mr.
screen
Bean,
for
good
this.
morning. Come on up again.
I'm right here with you.
All right, sir, you're still under oath, okay?
Yes, sir.
All right, thank you, sir. All right, cross. Mr. Steele?
Thank you, Your Honor.
Mr. Beam, come
You
through
were
with the
released from
branding.
prison in approximately 2017. Is that correct?
Yes, sir.
And since you've been released from prison, you have been gainfully employed. You've been working, right?
Yes, sir.
And you work for, I believe, currently, and if I'm wrong, just tell us, for the city of Atlanta, is that right?
No, sir.
Who do you work with currently?
I'd rather not say who I work for, sir.
Okay, what do you do currently for a living? How about that?
I'm a foreman.
And explain what type of foreperson.
Foreman.
You said a foreman.
A supervisor.
Okay, for what type of work?
Traffic control.
Okay, traffic control. I'm sorry, I'm having a hard time hearing you. Traffic control?
The traffic control.
Okay. And how long have you been doing that?
I really can't recall.
One more time.
I can't recall, sir.
Has it been more than 2 years?
Yes, yes, sir.
Okay. And are you working other jobs as well currently?
No, sir.
All right. With
We got a yes.
regard to your testimony last week, Thursday and Friday, you said a lot of, I don't recall 2013. Do you remember something like that?
Yes, sir.
And I think you explained or tried to state that that was a bad time in your life, you blocked it out. If I'm misstating that, just correct me.
You don't recall anything from 2013, sir.
And why is that?
Here we go.
I just don't recall. I don't remember. Just don't recall, sir.
Do you remember things in 2014?
No, sir.
No? Yes or no?
No, sir.
2015?
I don't recall, sir.
How about 2016?
No, sir.
2017?
I just remember what I need to remember in 2017.
That's after prison, is that what you're saying?
I mean, I was released from prison in 2017.
And is your memory good after 2017 released from prison? Do you remember whenever month, I don't know the month, you're released from prison, you remember that? Is that what you're telling the jury?
Yes, sir.
And you remember then 2018?
Your Honor, I object as to vague. That's a broad question and not specific
Okay,
enough.
all right. I'll sustain the question. Just rephrase, Mr. Steele.
Do you have a memory of things you did in 2018?
Again, objection, vague.
That was vague.
I'll let him answer the question. I'm all over the question.
Oh, wow.
You can answer it, sir.
2018. What I'm remembering in 2018.
You don't?
No,
What am I
what is he
remembering in
remembering?
2018, sir?
Anything, where you were working, how about that?
No, I remember where I worked in 2018, sir.
Come
Do you
on,
remember being
man.
home in 2018, not incarcerated?
Yes, sir.
All right, how about 2019, same question?
What am I remembering?
Same question.
Every year you asking me what am I remembering for every year that you ask me about this certain type of year? That's what I'm trying to get you to understand.
Answer my question. Do you remember
Answer his
where
question.
you were working
Stop
in
trying to swag out the
2019?
question.
No, sir.
Were you working in 2019?
I don't remember.
Were you living free in 2019?
I'm free.
Were you living with your wife in 2019?
I've been with my wife in 2019.
Same question, it's 2020. You remember that year where you were working?
I've been doing the same job for some years now, so it'll run until all that. It's 24 now. I've been working by 7, 8 years now. The working part is gonna be what you're asking me about, sir.
And you remember that in 2020, right? Yes or no?
Yeah.
And 21, same question.
Okay.
Remember
Yeah.
that?
I remember my work 21. I remember my work 22. I remember my work 23. I remember my work 24. This year right now, what we're looking at.
Oh, his memory's
How
back.
clearly do you remember 23 and 24 years? This year and last year.
Not too well, but
I can't hear you.
Not too good.
Okay. Mr. Bean. You remember being convicted of what has been marked as State's Exhibit number 157C, as in Colette or Charlie, that you identified last week. Do you remember that?
No, sir. I don't know.
Okay.
What?
Your Honor, with the court's permission, may I show electronically 157C in Colette? And Mr. Kokomo, if you can help me out.
Now pay attention to the
It's already in
jacket.
evidence, Your Honor.
Rebel minds to be prepared in
It should be on the
half
screen. You
is
can look
half
behind
the
you or right
victory.
next to you in a moment.
So is that
I
like
wanna go through this
contradictory
with
to what he's doing right now? To understand?
Okay, Mr. Bean, what's on the screen is been already admitted on March 1, 2024. This is the Superior Court of Fulton County, State of Georgia versus you. You see that on the left-hand side of that first page?
Yes, sir.
And you see where it says filed in the office of the Deputy Clerk of Superior Court, Fulton County. It gives the date of October 15, 2015.
It's gonna still be the same.
I can't hear you.
It's gonna still be the same. I seen this paper last week. The same paper Ms. Love showed me last week.
I just
The end
cannot
of
hear you.
Friday. It's gonna be the same thing. I seen this paper before.
Answer my question. Do you see it says October 15, 2015, filed in the office of Deputy Clerk, Superior Court, Fulton County?
It's right there.
Yes,
In
sir.
And you see in the next column to the right, there's a rectangle and it has your date of birth, June 22, 1979. True?
True.
Okay. And then if you go down on that page, with Mr. Kokomo's permission, you see it lists certain charges on the left-hand corner. You see that? Left-hand side? It goes from 1, 2, 3, 4, 5, 6, and then it skips to 9. You see that?
It's right there.
I see it.
Okay. And then it says in the disposition, you see 2 columns over, after it says charge, and then you see disposition.
Yes, sir.
And on count 1, it says guilty Alford. Right?
I don't know.
You
Do you
see
see
it?
it?
I see it.
I don't know.
We
I
mean,
can't hear
no.
I don't know.
Do you see it, is what I'm
I can't
asking.
really see it.
Yes?
Okay. Where you thing at? Yes, sir.
Okay. And then it says for the sentence, 10 years to serve 3 years. That's in prison, right?
Okay.
Balance probated 7 years, right?
Okay.
And then it says concurrent with, and it gives another indictment number. You see that?
So technically, he's
Okay.
still on paper.
And that's indictment number 14 SC 130460, which we're going to discuss in a moment. All right?
I see you, princess. I
Okay.
see you.
Yes? All right. Now, this is October 15, 2015, and the total sentence here is 10 years, right?
I don't recall it.
It's
Well, that
right.
was your sentence.
It's right
I
in
don't
front of
recall it,
you.
sir.
It's front in front of you.
This is the
Oh,
same
oh,
document
oh.
you recalled last week on the 1st of March, right?
I still didn't recall it.
All right. Count 2, you see on the left-hand side, count 2, it says aggravated assault against a police officer, vehicle on vehicle. You see that? You see that?
Yeah, I don't recall none of this paperwork right here, but you're showing me though, Mr.
All right, well,
well,
it's in
you s-
evidence, we're going to go through it. Again, you pled guilty under Alford, right? And the same sentence, 10 years is total sentence, 3 years in prison. The balance is 7 years on probation to run concurrent with count 1. Okay? That's what it says, right?
It's,
Yes or no?
It looked like that to
So we
me.
got to answer the questions, okay?
Answer the question. Cut the
It's on
crap.
screen. Yes, sir.
Count 3 is again aggravated assault against a peace officer. And again, guilty under Alford, 10 years to serve 3 years, balance, 7 years on probation, concurrent with count 1, right?
I never pleaded to this.
All right, we're going to talk about it. We'll go through the whole
Yeah,
document.
we're gonna go through this.
The next one is count 4, 5, and 6, and that's armed robbery, aggravated assault with a deadly weapon, and possession of a firearm during the commission of a felony, and all those were no pros were dismissed. You see that?
You remember
sir.
that?
All right, and then the last one is count 9, fleeing or attempting to elude, misdemeanor, and again, guilty under Alford, 12 months to serve, concurrent, run at the same time as count 1. That's what it says, right?
That's what it says.
All right, let's go to page 2 with Mr. Kokomo's permission. And these are the terms of the sentence summary. You see that right there where Mr. Kokomo stopped? You see in bold, it says sentence summary.
Send it some, yeah.
Okay, and defendant is a word used for somebody charged with a crime, right? You know that?
I didn't know that.
Like a plaintiff is a state or a
Man, you,
defendant is a person charged with
bro,
a
you
civil
was
case.
down
You know what
3
I'm talking
years
about?
with other defendants. You don't know what that means?
okay.
Come on.
Well, it says the defendant is a judge guilty. Excuse me, I'm in the wrong place. The defendant is sentenced for a total of 10 years, with the first 3 years to be served in confinement, the remainder to be served on probation, right? Then it says, or, and that it's not checked, to be served on probation. So you were sent to prison, right?
You don't remember? You was, bruh. Come on now. Come
You see
on.
that?
Come on now.
You say so.
Well, that's the
Yeah,
prison you're talking about with the
It's not
jurors.
that you say so. Did
that
you go to jail
you
or
said
didn't
you
you?
got out in about 2017, right?
Yes, sir.
All right. And then if you go down to the next line, the defendant, which is just the way it's termed, but you are to receive credit for time served in custody as determined by the custodian. That's Department
Corrections.
of Corrections for state of Georgia, right? You see that?
This guy's a foreman. He is a foreman. That means he has a leadership role in his job. You're telling me.
And then on the next one, which is box 2, it's checked. Upon the service of 3 years, the remainder of the sentence may be served on probation, provided that defendant shall comply with the conditions imposed by the court as part of the sentence. And then it goes through general conditions of probation and special conditions underneath. Okay? You see that?
Mm-hmm.
All right. And then Mr. Kokomo can scroll down and it's checked, or X, number 2. Probation supervision fee is waived for the first 6 months after release. You see that?
Yeah.
And then on the next page, it says special conditions of probation. And you waive your 4th and 5th Amendment rights, meaning you have to answer questions. Right? You know what the 5th Amendment is?
Your Honor, I object as to the commentary about having to answer questions.
I sustain the objection.
Do you know what the 5th Amendment
Your
is?
Honor, I'd
I
ask that.
sustain the objection.
For the 5th Amendment? Ask him if he knows what it means. Okay. You waived your 4th Amendment and 5th Amendment rights. You see that?
Why sustain whether or not this guy understand what the 4th and the 5th is?
I'm looking at it.
Okay. And then maintain employment, undergo regular random drug screens, obtain a GED, and then back to that court if your probation is going to be revoked. You see all that?
For those who don't know, 4th is search and seizure, 5th is self-incrimination.
I'm looking at it.
And revoked probation means you go back to prison instead of being out on the street under supervision of a probation officer, right?
I guess so.
You don't want to go back to prison, do you?
Boy, answer the question. Answer the question.
I mean,
What? Yes or no? That's a yes or no. That's a yes or no.
what do you mean?
Well, what do you mean?
I'm
What do
asking
you mean, sir? Do I want to go back to prison?
You don't want to go back to prison, do you?
If I had to go, I would. I went to prison.
Do you want to go back?
I've been to prison before.
You're a tough guy, I see.
Did you enjoy prison?
No,
I stand objection.
he sound like he enjoyed it. I'd go back.
I mean, I did mine. I did my time.
Did your time.
Underneath that, if Mr. Kokomo comes down,
10 toes down.
you hired a lawyer, go down a little more, named Ed Adams. You see that by employment?
Yes, sir.
Okay. And then that court was the Honorable Judge Downs, who sentenced you. You see that?
Judge
Yes, sir.
Dorothy Downs, a legend in
Now-
the Fulton County Courthouse.
Mr. Williams never paid for any of your lawyers, right?
Doris, excuse me. Sorry, Judge
No, sir.
Downs.
He never made any bond for you, right?
No, sir.
The next page of this document, 157C, as in Colette, Charlie, keep going down, is the indictment. I want to go through the indictment with you. Okay. If you go up a little bit. Perfect. Thank you, Mr. Kokomo. Go down just one more to get count 9. Now, on this indictment, Mr. Bean, in State's Exhibit number 157C, as in Colette, Charlie, you see the indictment number there in the center, written in 13SC122087. You see that?
Yeah, that's what it says.
And it says State of Georgia versus, and the first person is you, with count 1, 2, 3, 4, 5, 6, and 9. Same counts that we just discussed on the sentencing page. You see that?
That's what it says.
And then you have the next person charged is Walter Murphy. You see that name?
Yeah, that's what it says.
And he's the same Walter Murphy that you discussed earlier, according to, you said you didn't recall, but he was referred to by the Honorable District Attorney as DK. You remember that?
No, sir.
All right. And he is also charged with you in count 1, 2, 3, 4, 5, 6. Mr. Murphy's charged in count 7, but also in count 9. You see that?
That's what the paper says.
And then the last person is Frederick Medina, which is Medina, Prothro, Prothro. You see that?
Yeah, that's what it says, sir.
And Mr. Prothro is also charged in similar counts as you, but count 8. So he's charging 1, 2, 3, 4, 5, 6, 8, and 9. You see that?
That's what it says.
And this indictment was filed, if you go down a little bit, Mr. Kokomo. Originally, October 1, 2023. You see that?
It says 13.
You see that? I couldn't hear you.
I said it says 13.
Okay. And then for Walter Murphy, you see where he pled guilty to count.
Objection, Your Honor, as to having this witness testify about someone else.
I sustain the objection.
The documents and evidence.
It doesn't make a difference, Mr. Steele. That's a proper objection. I'm sustaining it.
All right. Let's just, before we leave this page, just go up a little bit, Mr. Kokomo. Show the jurors where Jeffrey Williams is charged, along with you, Mr. Prothro, and Mr. Murphy in this indictment.
You show me.
I cannot hear you.
You can see it clear as day. It's on the paper. You show me. He's not there.
He's not there. Now, October 1, 2013, the return of this case, that is after you spoke with Detective Quinn at the City of Atlanta Homicide Office on recording on September 17, 2013. You realize that?
No, sir.
All right, if you can scroll down, Mr. Kokomo. And Mr. Bean, this is the next page. And you see in the top, just talk about you. So I'm excluding the first column, Mr. Prothero, the second column, Mr. Murphy. We're going to the third column to the right on the top. You see where you originally pled not guilty with your lawyer, Ed Levance Adams, and your signature. You see that?
Yes, sir.
And that's, it says October 29, 2013. You see that?
Yes, sir.
And then if you go down, and it's on an angle on the side, or actually it's on the center right. You see where it says Adrian Bean with your middle name? You see that in the center, kind of right?
Yeah, that's what it said.
And you see there's a check mark. You pled guilty under Alford to the indicted offenses in count 1, 2, 3, and 9, like it says on the first page of 157C. You see that?
Yes, sir.
And that's October 1, 2015 now. So it's 2 years and 3 weeks after September 11, 2013 that you're resolving this case. You see that?
That's what the paper say.
One more time.
That's what the paper say.
Okay. And then the other counts, if you look kind of on an angle, as to Adrian Bean, count 4, 5, count 4, 5, and 6 is null pros. Null pros means dismissed, just like it was on page 1. You see that?
No, I don't see it.
Mr. Kokomo, can you just orient Mr. Bean? You see where that pointer is?
Okay, sideways though.
And that's also October 13, 2015, right?
I can't really see it.
Yes?
I can't really see it. Yeah, I see it, man. At the bottom.
You see it? Yes?
I say yeah.
All right. The next page of this document is the actual charges that you were facing along with Mr. Plethro and Mr. Murphy. And you see the names of the grand jurors in the center. It says a grand jury selected, chosen, and sworn for the county of Fulton to wit, and they charge you. You see that?
No, the paper say.
And count 1 charges you, Mr. Murphy, Mr. Medina, with the offense of aggravated assault against a peace officer for that the accused, that's you, and the other 2, in the county of Fulton, state of Georgia, the 11th day of September 2013, did intentionally drive and steer a motor vehicle at, towards, and in the direction of E. Robertson L., a peace officer employed by Atlanta Police Department as a police officer who was at the time of the said assault, engaged in the performance of his official duties as a peace officer, said motor vehicle being a means likely to cause serious bodily injury when used offensively against a person. You see that?
It's on paper.
Okay. And you were driving that 2004 Nissan Altima vehicle at the time that you almost killed Officer Robertson L., right?
I don't recall, sir.
Okay. You knew Officer Robertson L. before September 11, 2013, right?
I don't recall, sir.
And on this one count, you entered a plea under Alford, and we'll discuss what that means. 10 years to serve 3 years in prison, right?
Yeah, I don't recall it.
October 2015.
Yeah, I don't really remember anything.
All right, let's go to count 2. This charges, again, the grand jurors charge you, Mr. Murphy, Mr. Plethro, with the offense of aggravated assault against a peace officer. It gives a code section. You know what OCGA stands for?
No, sir.
You do?
No, sir.
Okay. For said accused, that's you, Mr. Plethro, Mr. Murphy, in the county of Fulton, state of Georgia, on the 11th day of September 2013, same day, did intentionally drive and steer a motor vehicle into and against the motor vehicle, which was then and there occupied by A.C. Booker Higgins, a peace officer employed by City of Atlanta Police as a police officer, who was at the time of said assault engaged in performance of his official duties as such peace officer, said motor vehicle being a means likely to cause serious bodily injury when used offensively against a person. You see that count?
And that's what the paper said.
And you pled guilty under Alford and were sentenced on that count, right?
No.
You didn't plead guilty
No.
to that count?
No.
Okay. Count 3. Grand jurors again charge you, Mr. Murphy, Mr. Plethro, with the offense of aggravated assault against a peace officer for said accused, county of Fulton, state of Georgia, on the 11th day of September 2013, did intentionally drive and steer a motor vehicle into and against the motor vehicle, which was then and there occupied by B. Porter, a peace officer employed by Atlanta Police Department as a police officer who was, at the time of said assault, engaging in performance of his official
Thanks for the
duties
super chat,
as
Galatians.
such
I
peace
see you.
officer, and motor vehicle being a means likely to cause serious bodily injury when used offensively against the person. And you pled guilty to that and were sentenced, right?
I don't remember.
Okay. Then count 4 is going to be no process against you, but the charge is that you, Mr. Murphy, and Mr. Plethro were charged with the offense of armed robbery for that you all in county of Fulton, state of Georgia, the 11th day of September 2013, did unlawfully with the intent to commit a theft, take from the person and immediate presence of Derek Dotson, United States currency, the property of Derek Dotson by use of a handgun, an offensive weapon. That case for you was dismissed, right?
I don't remember.
Or no process?
I don't remember still.
All right. Mr. Kokomo, just go back to the very first page of State's Exhibit 157 for a second, please. And scroll down to count 4, 5, and 6. You see count 4, armed robbery we just read, and then it says in the third column, disposition, no process. You understand that? The same with count 5 and 6.
That's what
Right.
the paper says.
Okay. Let's go to count 5. What was dismissed against you? You were charged in count 5, along with Mr. Murphy and Mr. Plethro, with aggravated assault with a deadly weapon for said accused in county of Fulton, state of Georgia, on the 11th day of September 2013, did unlawfully commit an assault upon the person of Derek Dotson by shooting at, towards, and in the immediate direction of Derek Dotson with a handgun, same being a deadly weapon. Your case was dismissed. That's what you were charged, right?
Yes, sir. The paper say.
And then count 6 is going to be the grand jurors charge you, Walter Murphy, and Mr. Plethro with the offense of possession of a firearm during the commission of a felony for that said accused, the 3 of you, in the county of Fulton, state of Georgia, on the 11th day of September 2013, did unlawfully have on and within arm's reach of accused person a handgun during the commission of a felony against and involving the person of another, to wit, armed robbery. And that case against you was dismissed, right?
That's what the paper say.
Okay. And then number 7 charges just Mr. Walter Murphy with possession of firearm by convicted felon. Count 8 charges Mr. Plethro, possession of firearm by convicted felon. And then count 9 charges you, Mr. Murphy, and Mr. Plethro with the offense of fleeing or attempting to elude for that said accused, county of Fulton, state of Georgia, 11th day of September 2013, did willfully fail to bring his vehicle to a stop after being given a visual hand signal to do so by E. Roberson L., a police officer employed by Atlanta Police Department in uniform, prominently displaying his badge of office in an appropriately marked police vehicle. And you pled guilty under Alford to that, right?
I don't remember.
The next page has again your name, your date of birth, has 6/22/79, and then Mr. Murphy and Mr. Plethro's information. And then if you go down to the witness list, you see the witnesses, Derek Dotson, and then the police officers, including Detective Quinn. You see that?
Yeah, it's the paper say.
Okay. Now, that same day, you disposed of another case. You remember that?
No, sir.
Your Honor, may I approach?
You may, sir.
May I approach you? I'm showing you what I've marked as dated today, Mr. Williams, number 199. You can look at the whole document, okay? I'm not trying to rush you. I mean, this is your signature.
No, sir. I didn't write that. I didn't write that.
Is that your signature?
I didn't write down one of them.
Is your lawyer, you recognize the signature of Ed Adams? That's your lawyer?
I don't know how his signature would be, sir.
Is that your lawyer?
Yeah, that was my lawyer, but I couldn't explain to you about his signature.
And do you remember being charged and convicted of aggravated assault with a deadly weapon for an incident on September 7, 2012, did commit an assault by shooting a person named Cameron Randolph? Do you remember that? I can't hear you.
No, sir.
You deny that.
I mean, if that what the paper said, I don't remember that. I don't remember nothing back then.
Do you remember being charged in count 2 with aggravated assault with a deadly weapon on the same day, September 7, 2012, by committing assault on James Butler by shooting James Butler?
No, sir.
You denying that?
Yes, sir.
You do realize you're on an oath?
Yes, sir.
Remember count 3, being charged and convicted of possession of a firearm by a convicted felon on the seventh day of September 2012, did knowingly and unlawfully.
I don't remember that, though, still.
Why are you looking
have
at the
a firearm
prosecutor?
to aid a handgun
Why is he looking at the
to a
prosecutor?
convicted felon from indictment number 01SC033786, Superior Court, Fulton County, charged with possession of cocaine with intent to distribute on May 18, 2021. Are you denying that?
Sir, I don't remember that, sir.
And then on the last page, it has, again, your name, your identifying information, including 6/22/79 as your date of birth, right?
That's what the paper say.
Okay,
And
now,
I have a certified.
so he's asking you about your date of birth, and that's what the paper says. Yes,
From the
come on.
Honorable Fulton County Superior Court Clerk for State of Georgia versus Mr. Adrian Bean, same lawyer, same date, judge down. I have the plea colloquy if you want it. And in fact, I have same date of birth on the document itself, and I move it into evidence.
Have you shown that to the state? What
Of
are you
course.
marking there, sir?
Mr. Williams, number 199.
Any objection to Mr. Williams 199?
State has no objection to the self-authenticating document that is the certified conviction. That is Williams 199. I'm not certain what the rest of Mr. Steele's representation is regarding a colloquy, but the certified conviction, the state has no objection.
All right.
I'll admit, Jeffrey Williams, 199, the actual certified copy of the conviction. The other allied documents can be separated, okay?
Your Honor, may I approach Mr. Bean with Mr. Williams, number 199 that's in evidence, as well as states 157C in case he needs to refer to them?
Yes.
May I approach you again?
I don't care. What? Yes, sir.
I'm showing you, and I'm going to leave with you in case you need to see them. Just let us know if you're looking at them. This is Mr. Williams, number 199 in evidence. This is State's Exhibit number 157C. Okay. With Mr. Kokomo's permission, Your Honor, I would like to show on display Mr. Williams, number 199, that's now in evidence.
All right, may be shown.
Okay, Mr. Bean, we are looking with Mr. Kokomo's permission at Mr. Williams, number 199. It's on the screen. It's also right in front of you if that's easier for you. You could look at either one. And at the top of that, on the left-hand side, again, it is State of Georgia versus you, Adrian Bean. You see that?
Excuse me, can I say something?
Not really. Answer my question, and then you ask the honorable court.
Is that what the paper say?
What'd you say, sir? I'm sorry.
That's what the paper say?
And then this is for indictment number. You see under it, criminal action number 14 SC 1306, 0460. You see that?
Yeah, that's what the paper say.
All right. And Mr. Bean, to the right of that, you see in that rectangle, it's the same date of birth for you, 6/22/79, right?
6/22/1979 has been stated to be my birthday. Yes.
Okay. And then underneath it, we are going to go to the charges. You entered a plea. It says a non-negotiated plea. You see that check mark right in the center top? Or it's not a check, it's an X.
That's what the paper say.
Okay. And then a little down, you're charged now in 4 counts in this indictment. And the first one is aggravated assault with a deadly weapon, as well as is the second count. The third count is possession of firearm by a convicted felon, and the fourth count is possession of firearm during the commission of a felony. You see that in the second column on the left?
That's what the paper says, sir.
And then in the center, well, it's center left, you see the disposition? You again entered a guilty plea under Alford to all 4 counts. You see that?
That's what the paper say.
And then next to it is your sentence. And you see the sentence now is 10 years to serve 3 years, balance of 7 years on probation. And that's to count 1 as well as count 2. You see that?
That's what the paper say, sir.
And then on the far right-hand corner, that says concurrent with the indictment number, which is in State's Exhibit number 157C, as in Collette, indictment number is 13 SC 12207. You see that?
That's what the paper say.
And then for count 3, and you get 5 years to serve 3 years, balance of 2 years probated. You see that?
Yeah, that's what the paper say, sir.
And that's concurrent with count 1 as well. Right?
That's what the paper say.
Okay. And then on the last count, it says 5 years to serve, suspended, consecutive to count 1. You see that?
Yeah, that's what the paper say.
And consecutive, you know, means run after, right?
I don't know what the consecutive means, sir.
All right, well, the sentence summary.
So he did all that time in jail. He don't know what consecutive versus concurrent means?
The summary is
Wow.
that you, the defendant, is sentenced for a total of 15 years The first 3 years to be served in confinement, the remainder to be served. And then if you go to the next page, the very top, you are to receive credit for time served in custody as determined by the custodian. And then number 2 is checked. Upon the service of 3 years in prison, upon the service of 3 years, the remainder of the sentence may be served on probation, provided the defendant shall comply with conditions of probation. And when you go down, Mr. Kokomo, they're going to be the same conditions that we discussed earlier for your other conviction in State's Exhibit 157C. You see that?
And that's what the paper said.
All right, and then if you go down to the date, keep going down, please. And there again, you're represented by your lawyer, Ed Levance Adams, by employment, and that's October, ordered the 14th day of October, 2015. You see that?
That's what the paper said.
The next page is going to be your indictment. And this is 14 SC 130460, charging you, Mr. Bean, with those 4 counts, 2 counts of aggravated assault, possession of firearm by convicted felons, count 3, possession of firearm during the commission of a felony. This indictment was returned on October 24th, 2014. You see that?
Yeah, that's what the paper says, sir.
And underneath that, it is stamped there, October 24th, 2014, same day the grand jury returned the indictment. And if you go down, you had first, on December 22nd, 2014, entered a not guilty plea, and that's on the left-hand side with your lawyer. And then in the middle of that page that Mr. Kokomo is showing, you change it to a guilty plea under Alford versus North Carolina to all counts on the first day of October, the 15th day of October, whatever that says, 2015. You see that?
Yes, sir.
And then you see underneath it's filed in the office of the clerk of Fulton County Superior Court on October 15, 2015, the same day as you were sentenced on the other September 11, 2013 crimes, right?
That's what the paper said.
And then on the next page, it shows the grand jurors charged you, and then in count 1, this indictment is only you. You're the only person in it, right?
How many times we're gonna look at it?
One more time.
How many times we're gonna keep looking at the same paperwork?
You're the only one charged, right?
I ain't charged. I mean, how many times we're gonna keep looking at the same paperwork that you're showing me?
You're the only one charged. Answer the question, please.
That's what the paper says.
And then it says in count 1 that the grand jury does charge and accuse Adrian Bean with the offense of aggravated assault with a deadly weapon for that said accused, County of Fulton, State of Georgia, the 7th day of September 2012, did unlawfully commit an assault upon the person of Cameron Randolph by shooting him with a handgun, same being a deadly weapon. You see that?
That's what the paper say.
Count 2 that you pled guilty to under Alford charges you with the offense of aggravated assault with a deadly weapon for said accused in the County of Fulton, State of Georgia on the 7th day of September 2012, did unlawfully commit an assault upon the person of James Butler by shooting him with a handgun, same being a deadly weapon. You see that?
That's what the paper says.
Now, this is approximately 4 days short of a year from then is September 11, 2013, when you were driving that red 2004 Altima, right?
I don't recall still.
Shout out to Trey for the $50 Cash App. Shout out to Tony for the $200 Cash App. Thank you. Thank you very much.
The next count is count 3, charging you with possession of firearm by a convicted felon in County of Fulton, State of Georgia on the 7th day of September 2012, did knowingly and without lawful authority possess a certain firearm, to wit a handgun, accused having been convicted of felony on indictment number 01 SC 03786, Superior Court of Fulton County, charge of possession with cocaine. of cocaine with intent to distribute on May 18, 2021, right?
That's what the paper says, sir.
That's about 11 years earlier than September 2012, right?
I guess that's what the paper say.
And you told the jurors that you've been through the prison system several times. Didn't you say that today?
Today?
Didn't you say that?
I said I've been in prison before.
All right. And then count 4 charges you possession of firearm.
And you
during the
say you don't have
commission
a
of
problem going
felony
back
for
either.
that
You don't got a
or it
problem.
says accused, excuse me, in the county of Fulton, state of Georgia, on the 7th day of September 2012, did unlawfully have on and within arm's reach of accused a person a handgun during the commission of a felony against and involving the person of another, to wit, aggravated assault, and you pled guilty to that, right?
I don't remember.
All right, and then on the next page, it shows the witness, it shows your name and information or some information, again, giving your date of birth as 6/22/79, and then the witness list against you. And you see that Mr. Billingsley, Mr. Butler, Mr. Randolph, and then those police officers. You see that?
Yeah, that's what the paper say.
All right. Now, Mr. Bean. I noticed several times on last Thursday and Friday that you were given a choice. Is your answer you do not recall information on statements that you gave on recording to Detective Quinn on September 17, 2013, or are you saying you did not?
Yeah, I didn't recall.
And you specifically never said that you denied that it occurred. You just kept saying, I don't recall. Remember that?
That's what I said.
Now, you know and remember September 11, 2013. The I don't recall is not true. You are not being honest to the juries. Am I right?
I don't remember, sir.
Do you recall
This guy is a problem.
meeting with me and investigator James Martin, private investigator, and we were trying to get in touch with you, and we caught up with you on Sunday morning, approximately 11 o'clock in the morning, on January 22 of 2023. You remember that?
Yeah, I don't really remember, though.
Do you remember saying, because we were in front of your house, I'll speak with you, but let's go to the nearby Kroger. Remember that?
Something like that. I mean, I don't really remember the conversation, though.
Do you remember Investigator Martin and me asking if we can record the conversation with you?
Okay.
Do you remember giving permission and said, that's fine?
Okay.
Do you remember me telling you, I only want the truth?
Got him.
Okay.
They got him.
Do you remember?
Your Honor, as to this.
You have an objection, madam?
Objection.
Right.
as
Speaking,
to
not a
say
not a
the
speaking
question
objection. Get her, Yana. Get her.
I think he's gonna ask them, so at least, is that your intent, Mr. Steele?
I have to lay the foundation.
Your Honor, I'd like to.
He's getting nervous now.
just to
Whoa.
foundation.
Come on now. Come on, Judge. This speaking objection is just unacceptable. It's unacceptable. Now you want to lay a foundation at sidebar? Wait a minute. Let the man get the question out. Is anyone else seeing what I'm seeing here? Look how quick Deputy District Attorney Adrian Love jumped up. Your Honor, wait. Objection. He hasn't even finished the line of questioning yet. Now you want to do a sidebar to know what he's about. This is insane. Bring out the tapes. Bring out the tapes. Mr. I don't recall. No, ma'am. Yes, no, sir. No. Just put it in the tape. Play the tape. That's it. Let the jurors hear the tape. Got him. Like the judge is like, wait, ho, he even saw that. He even saw that. He saw, wait a minute, hold on. If I'm going to help you, give me an opportunity. Don't just jump out there. I'm not saying judge is helping them, but I'm Judge Glanville, judge. I mean, this is just interruption. Some judges say, no, stay, judge, stay right there. No speaking objections, Your Honor. No speaking objections. We know what you're doing. And he keeps looking at her. Watch his eyes, ladies and gentlemen. He's looking at the prosecution table when the defense is asking questions. Why are your eyes wandering? Posture. Hand move. Watch his hands. Watch his posture. Not pasta, not like salad. Posture. I'm from the Bronx. Calm down. Adrian Love knows Tick gave us some hell. This guy's about to get caught up. There's a tape. Oh no, we didn't know about the tape. Got him. Ladies and gentlemen, make sure you smash the like, smash the like. Oh, the guy, tough guy now. Pulling guns on people, robbing, doing stick ups. Oh yeah. Takes a special kind of person to walk up to someone and put a gun to them. Give me your stuff. Come on. See, the problem is when they take these plea deals come with a contract. The contract might not be able to be collected right away, but they got a plea deal with this guy. They got some time in the state prison. They got some time in the back end, and then they got a contract that he has to come back in and testify. So these contracts that the prosecution in Fulton County has crafted for people taking pleas, it's a trap. It's like the 360 deal. Give me a little now, maybe give me a little later. And if you don't, we're gonna give you something back. These are trap off contracts because you're gonna get trapped. You're gonna get trapped. So when you think that your history is behind you, they can bring you back into another case. This guy has nothing to do with this particular case, but now he has something to do with this particular case. Right. Get on the stand and say, yes, I did, and I'll do it again, and get violated. See, this is a technique. Throwing still off. Objection, Your Honor. This is just crazy. This is crazy. Look at Thug. He like, this is a damn shame. She's interrupting our defense, but we quiet when she's putting on her case. I hear you, Thug. I hear you. Yeah, Still's cooking their case up. That's what he's doing. He's roasting their case. I think since I've been in that courtroom, I think I heard her speak probably one time in the court. The older woman with the gray hair. I don't know if she's a lawyer, but I think she's a jury expert. But she's definitely a part of the defense team, and I don't think she missed a beat. She's been there every day. Dita Diva, what's up?
All right, ladies and gentlemen, it's not church yet. Come on now, stop fanning, all right? Okay, all right. Not that hot. All right, ladies and gentlemen, we are going to take a comfort break, and then we're going to go ahead and take lunch, okay? So we'll come back for 2 o'clock. We're going to go about an hour at that point in time, and then that'll be the, I'll make some administrative announcements at that point in time, okay? All right. So remember the admonitions I've given you. Enjoy your lunch. We'll see you back at 1 o'clock. I should say 2 o'clock. Okay. All rise.
All rise.
Where you going? Oh my God. Enjoyed those immensely. Oh, I could have. They're like, I could have eaten those all afternoon. All right, ladies and gentlemen, please be seated. The door. Deputy, can you get Mr. Bean, please, sir? Thank you. Mr. Bean, just hold fast, stand fast. I'm going to release you for lunch. Come back for 2:00. I'll be back here just a little before 2. Don't discuss testimony with anybody except the attorneys in this case, okay? Okay, see you then. All right. Councils, we're gonna be in recess until 2:00. Can I see Mr. Love and maybe Mr. Steele and Mr. Matthews? Can you all come up for a second, please? All right, we're in recess.
Ladies and gentlemen, the court is in recess. I'm in the background getting my eat on, but I'm coming back. I'm coming back on screen, ladies and gentlemen. Here's I am. I'm back. I was literally getting my eat on. The judge was eating at the bench, and I was eating at my seat. He's not just going to be eating, and I'm not going to be able to eat. What the heck going on here? You know they bring snacks into the media room, but they've been bringing candy and all that. No. Bring some fruit. I appreciate, the gesture, but bring some fruit in there. Don't be bringing candy and sweet. I'm not a diabetic, but come on. You have the YSL blogger bringing in Krispy Kreme donuts. I'm like, wait a minute. I ain't gonna be eating none of your donuts. But come on. Bring the healthy food. Bring the vegan food. Come on. Anyway, ladies and gentlemen, so what's happening here with this witness is that we now learn that not only does he have a probation that expires in 2025, but it does appear that he has another probation that expires later on. So he has to cooperate with the prosecution, even though he doesn't have anything to do with this particular case. He knows some of the co-defendants, but they brought him back in to give testimony as it relates to one of his criminal acts. But in his indictment, Young Thug is not listed on that indictment. So I have to ask the question, why is he even there? Why is he even sitting in the courtroom talking about nothing? Because he's giving nothing. But we want to hear what's on that tape. The tape may be telling. And we know they're going to bring in Detective Quinn. But if he can get the tape in before Detective Quinn takes the stand, that's going to be interesting. Because what he said in 2023, January 2023, hey, you know what Still said? He said, well, we can't talk in front of my house. Come, let's go to the local local Walmart. That's it. So he likes to talk. He is a cooperating witness. The question is he cooperating for the state and the defense? What's going on here? We're going to see. We're going to see what happens. With that, ladies and gentlemen, we are out on a lunch break. So I will be back relatively soon in the next 20 minutes. Unless you guys want to discuss another topic and not allow me to eat my lunch, and when I come back, my stomach's growling. You don't want to do that. Let me just go take my lunch. Because I know this guy's not going to let me interview him. I want to interview him, but he's not going to let me interview him. Because he's not going to give me anything. I don't believe he's going to give me anything. But like the judge tells all the witnesses, don't discuss your case with anyone until the conclusion of the trial. Right. Meet me in secret. Well, my guess is he had something to offer the attorney. Because he didn't want that investigator and the lawyer pulling up on him on a Sunday. They pulled up on a Sunday at 11 o'clock because they couldn't get him. So they staked out his house and they caught him on a Sunday because it wasn't planned. Because if it was planned, you would have automatically met him at the supermarket. They were staking his house out. They staked his house out, and then when he pulled up, they pulled up. That's what happened. All right, ladies and gentlemen, I'm going to take my lunch. I appreciate you guys I really do. Make sure you are back here 2:00 sharp. Don't be late. But we're gonna give you the court seal for right now. With that said, ladies, I appreciate you. Ladies and gentlemen, I appreciate you.
Stand by for breaking news. Stand by for a breaking news story. Stand by. All right, ladies and gentlemen, we have a breaking news update in the case involving former President Donald Trump. Before we do that, we need to move this out the way. Hold on, ladies and gentlemen. Hold on. The United States Supreme Court has ruled in a 9-1 vote that Trump can stay on the ballot in Colorado. What does that mean? That means that any other state that is attempting to remove him off the ballot will fail. So we saw last month and 2 months ago that there was an attempt to remove Donald Trump off the ballot in several different states. Well, the United States Supreme Court said, no. He can stay on the ballot. You have no power to remove this front runner for the Republican Party off of the ballot. So yes, Donald Trump will remain on the ballot in Colorado and in every other state that he's on. So that attempt failed miserably. While it was an interesting play, the United States Supreme Court stepped in and said, no, you cannot remove the former president or any president for that matter off the ballot. This is preventing any
attempt by others to remove him. What do you guys think about this? When you heard it, did you think that they were actually going to try to steal the election that way? Because that would have been an interesting play. You don't have to, you would have had to technically write him in. But no, they said no, he stays on the ballot. And that's just crazy that they even attempted that. That's never happened. To take a sitting president, a former sitting president, well, he's not sitting anymore, but a former president, and remove him off a ballot when he's the front runner for his party. Well, the 9-0 vote consisting of Clarence Thomas, Brett Kavanaugh, Coney Barrett, who else is there? John Roberts, Gorsuch, Sotomayor, Sonia Sotomayor. Oh, did I get all of them? Did I get them all? K. How many did I name? I think I named almost all of them. I think I named most of them. Did I say John Roberts? John Roberts. But the 9-0 vote means it was a unanimous decision. Unanimous. You can't take them off the ballot. That's it. Got to try something else. Like vote fairly, maybe. That is crazy. That they tried him. They tried to play the former president's gangster. He said, no. And a 9-0 victory for former President Trump. This is not looking good. This is not looking good for those Democratic states that were trying it. And it also shows a serious problem in democracy that you want to remove someone off a ballot, even though they have millions of people that support them. Bad play on whoever's part that decided that. Bad play. But let's see what happens. Anyway, ladies and gentlemen, we are still on a lunch break. We have to return in 30 minutes. I thought that was important because we're coming down the wire. We have several criminal cases pending in different jurisdictions involving the former president. And this attempt failed miserably. With that said, please join us back at 2 p.m. when we resume trial coverage of the Young Thug trial. And if we have any other stories that are breaking, you may want to be locked in. At least keep your sound turned up, because when we come back, it may be for the trial or maybe for another breaking story. Never know. But make sure you locked in. Make sure you smash the like, turn your notifications on, and make sure you tell a friend that we got it live here on Hip Hop Enquirer and on our official backup page at Mr. Dennis Byron. Make sure you guys are locked in. Thank you.
consecutive to count one. You see that?
Yeah, that's what the paper says.
And consecutive, you know, means run after, right?
Okay, guys, we are back from lunch. We are back from lunch. What a great lunch it was. Waiting for the jurors. Waiting for the jurors. Hope everyone had a great lunch. I did. We're just waiting for the jurors. I'll see you guys in a second.
All right, Judge, easy. Keys in the courtroom.
Okay, yeah. All right, we're going to summon our jurors, okay? All right. Sergeant Ingram?
All right, stretch if you need to stretch. 'Cause we just have about 3 more hours to go.
All right, ladies and gentlemen, please be seated. All right, thank you, Sergeant Ingram. All right, Mr. Steele?
What you got, Brian? What do you got?
Do you remember after driving the 2004 Nissan Altima vehicle into the side of the building, the laundromat, do you remember being arrested?
I don't recall, sir.
Do you remember that after being struck by the police car, you were then handcuffed and taken into police custody? Same day.
No, sir.
Do you recall then being taken to the hospital, Grady Hospital, for injuries?
No, sir.
I couldn't hear you.
No, sir.
Talk
You
up.
don't
Talk
remember.
up.
Do you remember in Grady Hospital, a law enforcement officer, detective with the City of Atlanta Police Department coming out and speaking with you?
No, sir.
My statement was I don't remember that
Oh,
from 2013, sir.
Do you remember that while at Grady Hospital, this is before ever being taken to the Fulton County Jail, you spoke with that detective?
No, sir.
Do you remember the detective asking you questions about the incident involving the armed robbery of Mr. Dotson and almost killing police officer Robertson L. and striking the other police officer's vehicle and careening over the embankment into the wall and fleeing? Do you remember that?
No, sir.
Do you remember telling that detective, specifically Detective Lewis, at that time, that there were 3 people in the Nissan red Altima vehicle?
No, sir.
Do you remember
Oh, so you were
telling
snitching.
Detective Lewis, or whoever the detective is? You don't have to remember a name. This is a long time ago. That the driver was not you.
No, sir.
Do you remember lying that the driver was not you and saying that the driver was your dear friend, Fred Plethro?
No, sir.
Fred Plethro and you are good friends, fair to say, or were good friends?
I don't recall, sir.
You don't know
remember
this guy.
stating that Fred Plethro is like your brother?
No, sir.
You've been
Wow.
arrested and indicted with Fred Plethro in the past, right?
You're
Not
co-defendant.
only the September 11, 2013 case, but other case, right?
No, sir.
You deny that?
Yes, sir.
Are you perjuring yourself now? Maybe bring some medical records. This guy has some kind
To
of.
be fair to you, and maybe it doesn't need repeating.
I don't remember no case from
Let me just finish speaking.
Fred.
Let me just finish speaking, then what did you say? I apologize. What did you say?
The same thing I've been saying.
What was it? Smart.
Okay. I didn't hear what you just said about Fred Plethro.
I don't remember no case with him.
Okay.
Being indicted with him. No, I don't.
This guy's ticking me off. You get it? Tick. Yeah, he's wearing that mask for more than just having a cough, in my opinion. You don't want people to recognize him. I get it.
Let me show you what I've marked as Mr. Williams number 200, exhibit number 200.
Exactly, Shantae. He done sung like a Michael Jackson for these police.
Your Honor, I'd like to.
Just play another tune. Oh, you want to approach everything. You want to approach everything. Let him cook. Let him cook. This interruption. Like, come on, let the guy hang himself. Listen, let me tell you something, about Detective Quinn. Detective Quinn, when you see him testify, at least the Detective Quinn that I've seen testify, it's very convincing. He's very convincing. He brings that swag to the stand. Very animated. I may have to pull one of the clips I shot of him on the stand. If you want me to pull one of the clips of Detective Quinn on the stand, put a one in the chat. Not in this case, but in another case. Put a one in the chat. Let me see if I can find the clip. Adams is out until next week. He's on trial in another court. Yeah, I think I'm gonna pull Detective Quinn's clip. That's what I'm gonna do. I'm gonna pull Detective Quinn's clip. These sidebars. She know what's about to happen. He's about to cook. He's about to roast your witness. He's about to tear a new one. All this I don't remember. I don't recall. I said what I said. And I'm not gonna say it again. Can we approach? Let him at least. Let's see where he's going. Give him a little latitude here, because this witness, it's gonna be jujitsu in a minute. You gotta put him in a uncomfortable position. Now start asking the questions, because now we're learning more about this guy. He's talking. Well, he's not talking, but now he's going to really talk. Confront him. He was doing a lot of talking. Hey, it was me and my boys in the car, my best friend. Yeah, we all did that. We did that. Now you don't recall. My spider sense is telling me that you recall everything.
Come on.
Let's go. Bring it on. Let's go.
Thank you, sir. Your Honor, may I approach Mr. B?
You may.
May I approach you, sir?
Sir.
Say yes.
Yes, sir.
I'm showing you what I've marked in today's date, Mr. Williams, exhibit number 200. Take a look at that. Tell me if you recognize what is in Mr. Williams number 200. Recognize it?
I don't recognize none of it.
Okay. Your Honor, I move for the admission of Mr. Williams number 200, self-authenticating certified copy of the indictment from the Honorable Clerk of Court, Fulton County.
Of course, you don't remember
Indictment number
anything.
11 SC 102083 for purposes of impeachment.
Any objection, Ms. Law?
Of course she's going to object. Oh, my bad. He's about to be impeached.
Mr. Kokomo, thank you so much. All right, this is Mr. Williams on the screen. It's also in front of you, sir. This is indictment number 11 SC 102083. You see that in the center top part of this page?
That's what the paper says, sir.
And you see it's State of Georgia versus a gentleman, Mr. Frederick Prethrow, counts 1, 3, 4, 5. You see that?
That's what the paper says.
Then a William Herman Green with an E at the end. You see that?
That's what the paper says.
Also, Shajuana, if I mispronounce, I apologize. Shajuana Bean, same last name as you.
Wait a minute.
That's what the paper says.
And that's count 1, 3, and 4, right?
1, 3, and 4.
And who is, if anyone, in relation to you, that person?
Objection, Your Honor.
Why? It's very relevant. He's on. What?
All right. And then your name is at the end. See, Adrian Bean, count 1, 2, 3, 4, and 8. You see that?
That's what the paper says.
Okay. And on the right-hand side, it gives the charges. You see that, 1 through 8?
Yes, sir.
Possession of marijuana with intent to distribute, possession of cocaine with intent to distribute, possession of firearm during commission of a felony, possession of firearm during commission of a felony, again, possession of firearm by a convicted felon, possession of firearm by a convicted felon, again, count 7, obstruction of a law enforcement officer, misdemeanor, possession of firearm by a convicted felon. You see that?
Yes, sir.
And then you see, if you go to the, keep going to the right part of that page, it's written at an angle. You see that it says that upon the motion of the assistant district attorney, the within indictment is ordered placed on the dead docket, and the surety, meaning bondsperson, is relieved of liability in this case. This the 25th day of July 2011. You see the judge signature, and that says as only to you. You see that?
As only to you. The gun toting.
Okay.
The gun toting.
And then
I don't
on the
remember.
next page.
So he has a lot of firearm cases. A lot of firearm
It has
cases.
people's guilty or not guilty. Then the next page, which will be the third page of this document. These are the charges that we just discussed. And I'd like to just look at.
Your Honor, I would object as to the presentation of the detail within the document. Improper impeachment.
Documents and evidence, and it's a dead docket of pending case.
Same thing. She's objected, it's a valid objection. Remember what you offered it for.
It's a dead docket.
I'm sustaining the objection.
Understood.
Oh my
Then
goodness.
turn to page, please, where it says at the very bottom, witness list. Do you see that?
Your Honor, once again, I object to Mr. Steele getting into the specific.
I sustain the objection.
Your Honor, I am showing that a witness in this case is Officer Robertson L. Robertson L. I'd like to impeach the witness that he didn't know who that was.
Your Honor,
That's not what you offered it for, so I'm going to sustain the objection. Remember what you told me you were going to offer, what you offered the doctor for. I'm admitting for that reason and that reason only.
Okay. All right. Mr. Bean, does this change your testimony in front of the jury that you've never been charged or indicted with Mr. Frederick Prethrow again? Or besides the September 11, 2013 case?
The document you show says that. I don't remember.
All right. And Mr. Prethrow was a close, dear friend of you in the early 2010, 11, 12, 13 period. True?
Your Honor, I object to that compound question.
I sustain as to form. You can rephrase, Mr.
Oh my goodness.
Considered Mr. Prethrow a close friend in year 2011, right?
No, I didn't, sir.
2012?
No, I didn't.
2013.
No,
I
I didn't,
didn't.
sir. I didn't remember.
Did you say
Go
something?
ahead.
No, you go
Did
ahead.
you say something?
No, sir.
Did you remember telling, and didn't you tell Detective Quinn on September 17, 2013, that Fred Prethro was like a brother to you?
I don't remember any questions that I had with Detective Quinn, sir.
Do you remember telling me and Investigator Martin on January 22, 2023, that Fred Prethro was very close to you?
I don't remember that either, sir.
Why did you tell the detective with City of Atlanta Police Department homicide at the hospital before you go to the Fulton County Jail?
Yeah, I
on
object
basis?
that that's not an evidence, and I really object to that. This is-
Wow. What
this
kind?
is asking a witness about something that isn't in evidence and will not.
It's his statement, Your Honor.
Your Honor.
I'm
There's-
going to overrule the objection. Let me ask the question, okay? We'll see where it goes from there.
Why did you tell the detective
Sit
at the
down.
hospital, Grady Hospital, on September 11th, 2013, that it was not you, but your dear friend driving that
I
Nissan
object.
vehicle?
There are no facts that are in evidence. There will be no statement put in evidence.
That,
So I object to facts not in evidence.
Did he make the statement, Mr. Steele?
yes.
Mr. Steele does not have any such statement. And there is no evidence that will say.
Can I see it?
Yes, sir.
Let me ask it this way. Do you have a good faith basis?
Yes, sir.
All right, I'm going to overrule the objection.
Uh-huh.
Do you remember at time of 44 minutes, 56 seconds on September 11th, 2000? That's wrong. That's wrong. I apologize. Do you remember on September 17th, 2013, on the recording with Detective Quinn at 44 minutes and 56 seconds, telling Detective Quinn that, yes, sir, I lied to the detective when they first came and talked to me, and I told them, and that's probably the lies you're talking about. I told them Big Fred was driving, and I was the driver. Big Fred was the passenger. Do you remember saying that?
No, sir, I don't remember that, sir.
Why did you tell Detective Quinn on recording at that time, stamp that I just said, that your dear friend is driving the car that almost killed a police officer?
I don't recall that, sir.
Liar,
Why
liar,
did you
pants on
tell
fire.
Detective Quinn that you typically use your cousin's name when getting arrested so you don't get arrested and they pull up your history?
I don't recall that either, sir.
Why would you use a cousin or any other person's name so you could get out of trouble but get them into trouble? Why would you do that?
I don't recall that either.
Oh, he's a piece of.
When at the hospital,
Your Honor, I object to the hospital statement because that is the part that is not in evidence and that will not come into evidence.
Oh, you
Is there
don't.
a statement?
yes, sir.
I'll rule it.
Show that to Miss Love. You have a good faith basis, that's fine.
I sent it to Miss Love this morning before 6 o'clock a.m. It's a 10-minute recording.
It is not a statement at the hospital. It is a statement with Mr. Steele in 2023.
Mr. Bean admits to making that statement at the hospital. This is all proper.
And you probably need to orient him to
Before
you ask that.
the statement,
Okay.
the recording.
Your Honor, can Mr. Kokomo come forward with headphones and play the 10-minute recording for Mr. Bean then?
I think you need to ask him some more questions in order to do that.
Okay. Do you remember having the ability to make a phone call or phone calls from the hospital from non-recorded lines to your wife, Courtney Bean?
I object to facts not in evidence. There's, as Your Honor.
I sustain the objection. Why don't you lay a little more foundation, sir?
Calm down, counselor.
Have you, when you were prosecuted for this case that you're here about driving that you pled guilty about driving you pled guilty under Alford for driving the vehicle, almost striking the police officers. We discussed that in 157C States Exhibit. That's what I'm talking about, okay?
Yeah, that's what,
Answer for
you
the
saw.
record. You
You
understand
have to
what?
answer for the record, okay?
Yeah, I'm
All
out.
right.
You got
You
Yeah,
understand?
I seen some on paper, but I don't remember.
Okay.
Judge, get to control this witness. Tell him sit up. He's got leaning back like he's in a damn bowling
On
alley.
that case, before going to Fulton County Jail, you went to Grady Hospital. Remember telling me that? And Jimmy Martin Jr. on recording?
I don't remember in the conversation we had, Mr. Steele.
And it's me. I'm confident it's not you, so I apologize, but I can't hear you. I know you said you can't remember, but then there were other words. Can you repeat
What was
what
your
you
name? Mr. Steele, right?
Yeah.
Yeah, that's what I said.
What did you say, though?
I don't remember any conversation that me and you even had, sir.
That's a liar. A liar. He lied to the police. He lied on his family member. Like,
You remember
what's going on?
Sunday, January 22, 2023, approximately 11 o'clock a.m., listening to a jail call that Jimmy Martin Jr. played for you in my presence at the Kroger restaurant near your, Kroger grocery store near your home.
I don't remember any conversations I had with you, Mr. Steele.
Do you remember at that Kroger restaurant, Kroger grocery store near your home on the same date? You're all going to be the same date. Sunday, January 22, 2023, approximately 11 a.m. Jimmy Martin Jr. and I introduced ourselves to you, and I made it known that I represent Mr. Jeffrey Williams, performer known as Young Thug, in this pending case. Do you remember that?
I don't remember any conversation we had, sir.
Do you remember being asked your telephone number by Investigator Martin and giving him a number? I'm not going to say it except for the last four numbers, 0730. Do you remember that?
No, sir.
Do you remember being asked by Investigator Martin your date of birth and giving it as June 22 of 1979 and stating that you're 42 years of age?
No, sir. I'm 44, sir.
Well, today you're 44. How old were you on January 22, 2023?
I was 43 then. I wasn't 42.
Do you remember me asking you, is it okay for Investigator Martin to record verbatim our communication there at the Kroger on that same date, approximately same time?
I don't remember any conversation we done had, sir.
Do you remember explaining that Dirty Red, or a gentleman known as Derek Dotson, was a good close friend of you?
I told you that.
One more time.
I told you that.
Do you remember that?
I don't remember that either, sir.
Do you remember explaining that Fred Prothro and Walter Murphy, DK, I'm saying, were with you on September 11, 2013?
I don't remember that either, sir.
Do you remember explaining that you were never charged with any crime involving Derek Dotson or Dirty Red? Do you remember that?
I don't remember that either.
And if you look at State's Exhibit number 157C as in Colette or Charlie, it's in front of you. You see that document?
Yeah, I've seen a lot of papers that you presented, but I don't remember none of them like that.
Okay, well, look at the State's Exhibit number 157C. It's right in front of you. You see it?
Which one is 157C, ma'am?
One more time.
Which one is one?
You're on.
Okay.
And
want me to look at it?
You can look at it. It's in evidence. And the charges against you by the grand jury were dismissed as to anything involving Derek Dotson.
He keep looking
like
at the
you said,
prosecutor.
On January 22, 2023.
Watch his eyes.
Correct?
I don't remember.
He keep looking at the prosecutor.
Do you remember explaining when talking about that entire incident involving Derek Dotson, Fred Prothro, Walter Murphy, driving, careening into the side of the laundromat, that Jeffrey Williams or Young Thug or Thug was not involved in any way?
I don't remember the conversation, sir.
Do you remember then explaining that they, meaning the detectives, tried to force Jeffrey Williams or Young Thug into it? Remember saying that?
I think that was something you said, right?
No.
I don't remember that.
Okay. Do you remember explaining that the police wanted Thug in it and there was a lot of, quote, hype on the street?
I don't remember, sir.
Do you remember again emphasizing that Jeffrey Williams or Thug or Young Thug was not involved in any way on September 11, 2013?
Be a man. Speak
I
up.
don't remember the conversation, sir.
Oh my
Do you
goodness.
remember me referring to that jail recording between you and your wife made from the Fulton County Jail? And I asked you, what did it mean when you said, quote, they gave us a story to tell? Remember that?
What?
No, sir.
Do you remember explaining that what you were referring to is that at the hospital, the police were telling us to lie, put Young Thug in on it, or face a lot of time in prison?
Wow.
Remember saying that?
I don't remember the conversation.
Play the tape.
Do you remember explaining that you were the driver of that 2004 Nissan Altima vehicle, red vehicle, on September 11, 2013?
I don't recall.
But explaining that the police wanted you to make Young Thug the driver. Remember that?
Oh no, play the tape. This is
I don't remember, sir.
this is crucial. Play the tape.
Do you remember explaining on January 22, 2023, that you told the police on recording that Jeffrey was involved in this crime because you wanted to serve less time in prison?
No, sir.
Pass the cheese.
Do you recall explaining that you made calls from the Fulton County Jail that you knew were being recorded to support your lie to the police that Jeffrey was involved on September 11, 2013?
No, sir.
Do you remember again emphasizing that Jeffrey Williams, I call him Jeffrey Williams, Thug, whatever you call him, was not involved at all with this crime?
I don't remember, sir.
Oh,
Do you
you
remember
oh,
explaining that Derek Dotson died, God forbid, before your case came to the court, and therefore all the cases involving Derek Dotson were completely dismissed as to you? Remember that?
I don't remember, sir.
Do you remember
this guy
explaining
has
that you got
no
3 years to
backbone.
serve
No
in prison for
backbone.
shooting 2 people in addition to this case?
I don't remember the
So
conversation.
he can carry a
Do you
gun,
remember
put guns on people, but he can't stand in the court,
explaining that you are
stand
not
on business.
involved with any criminal street gang, and that September 11, 2013 was not criminal street gang activity? Remember that? Basis.
Compound?
Assuming that's not an evidence.
Oh my goodness.
That's what he said on recording.
I'll rule the objection.
Do you remember saying that?
I don't remember still.
And Your Honor, I also object as to compound, because we don't know which question you.
I see.
I'll refer, I'll sustain it as a no, I'm afraid, Mr. Steele.
Do you remember explaining that you are not a part of YSL if it is a criminal street gang?
I don't remember, sir.
Well, are you part of a criminal street gang?
No, sir.
Do you have any tattoos of gang activity?
No, sir.
Do you remember explaining that you only know Young Thug, Jeffrey, through radio and seen him in the neighborhood?
Yes, sir.
What? We got a yes.
Do you remember
Whoa!
stating that Young Thug was not in any vehicle with you?
Your Honor, I ask that the witness be oriented as to when. And
So what's the objection?
Objection is to, form the question.
Speaking
I
of
sustain
objections,
the objection.
speaking
You
of
can
objections,
phrase
Do you remember explaining again on January 22, 2023, on recording to Investigator Martin and myself at the Kroger's near your home that Young Thug was not in any vehicle on September 11, 2013 with you?
I may have. I don't remember the conversation though. Still.
Do you remember
Okay, he's
explaining
loosening up,
that
loosen him
Young
up,
Thug,
loosen him up.
who I
Pause.
call Jeffrey Williams, never directed you to commit any criminal activity?
I don't remember.
Oh,
Do you
my
remember
goodness.
explaining that on the street, everybody wants to go against the man? They want to go against Young Thug. He's got the money. Remember saying that?
Your Honor, I object and ask that he.
Oh, wow, this guy's a piece of
Still, Mr.
crap.
Quorum.
Do you remember on Sunday, approximately 11 to 11:22 at Kroger's near your home, stating on recording to Investigator Martin and me
He's a
that
hater.
the street wants, everybody wants to go against the man, Young Thug. He's got money. Remember that?
I may have said that.
One more time.
I may have
missed
said
it.
something like that.
Whoa,
Do you
okay.
remember explaining that all you know is that
It's on the tape.
Thug is in the studio?
I may have said something like that. I don't remember though. Still.
Oh, you may have.
Do you also remember giving your opinion that Derek Dotson killed himself? This is a 10-year-old matter and this should be over with. You remember saying that?
Something like that.
Okay. This guy has he's a smart guy. He knows when to respond to the affirmative where it doesn't really hurt him.
When you were prosecuted for what's in State's Exhibit number 157C is in Colette or Charlie, when that case was prosecuted, you received what's called a sharing of information or discovery, you and your lawyer, from the state of Georgia. Remember that?
Never received one, sir.
Okay. Do you know whether your lawyer received one?
Objection is speculation.
If you know.
I'll rule the objection.
I never seen a discovery.
I cannot hear you.
I never seen or had a discovery.
Do you know if your lawyer's
Have you ever seen
That was the question. Do you know if your lawyer's seen it?
any of the memorandum, recording, note of your meeting with the detective at the hospital on September 11, 2013?
Objection, assuming facts that are not in evidence. There's no good faith basis for that. There's no such,
You all come on up.
Oh my. This is not good. Why couldn't the judge just make his ruling from the bench, not bring people up and come on? Doug, don't even know this guy. This guy's out here ratting on his people, lying on his people, pulling guns out, being a stick-up kid, and he can't even man up and say
what his involvement was and what he said to free up Thug, free Thug from these lies. What is happening here, ladies and gentlemen? We are sitting here listening to a prosecution witness saying nothing. He knows, oh, that's why I still got to play the tape. Got to play the tape. If you're going to impeach him, impeach him. Play the audio. Let everyone hear. Let's don't make this a mystery. We don't want this to be ambiguous to the jurors. We see what we have here on the stand. Let's see what he says in the recording. Let's see how fluid his answers are when he's being questioned by Still and the investigator. That's what we need to see. I don't know. At some point, I said, Yana, the foundation's been laid already. He's produced indictments that have been either nolle pros or dead docketed. He's been confronted with the crimes that he has actually pled to. He's given statements to a detective, Detective Quinn, apparently in some kind of hospital visit, made statements on a phone call that he knew that was being recorded. And this is kind of weird. Play the recording. Play the recording. I mean, they're trying to slow cook this case, it appears. You're slow cooking the case with weak witnesses. You should have vetted this witness. If he wasn't coming in to give you something solid, you asked him a series of questions, prosecution, knowing he's not going to answer to the affirmative, but you put the questions out there. So these are all the questions that he's been put out there where the jury can hear, but he's not answered to the affirmative. Talk about tainting the jurors' minds. I don't know. This is not feeling right. We saw Tick's testimony. We saw a bunch of witnesses come in, and no one has concretely said Young Thug is the leader of a major street gang. I'm not getting that. And the taxpayers are paying for this. Come out with your heavy stuff. What is all this? This is so unnecessary. Because if you had the smoking gun, you would have played it already. I guess the question I have is, how much more of this do we have to endure? How much? Connect the dots. Connect the dots. You know how they were connecting dots in the hearing involving District Attorney Fighting Willis and Nathan Wade and Terrence Bradley and Miss Yurdy? They were connecting the dots. This is not connecting the dots. They were trying to apparently make a case against Young Thug for a long time. You got detectives allegedly telling this guy, we got to get this guy. We got to get him for what? He may have been in the gang early on, but he ain't in the gang now. He probably left all this. Again, we have not seen any
money that he benefited from? I mean, his name is solid in the music business. What are we talking about here? For real. This is not good. Not good at all. You got this old lady sitting here. She's been sitting here. She's gonna sit here for 2 years. 2 years. Waiting for this case to come to a conclusion. Down to the cell tower. The triangulation of those phone calls was powerful. Shout out to Steve Sadow, and I'll say Steve Sadow represents former President Donald Trump. And I'm gonna tell you something. Steve Sadow has been a part of some very big cases you guys don't know. True story. I was in the federal courthouse when rapper Ti was facing charges on weapons possessions in Judge Baverman's courtroom. I was right there sitting in the jury box because at that time it was just media sitting in the jury box. When Steve Sadow presented 2 checks of $1 million apiece, saying, Yana, we'll put up $2 million for his freedom. And ultimately, Steve Sadow, along with Dwight Thomas, got him off. T.I. came in with 4 of the hottest: Don Samuel, Steve Sadow, Dwight Thomas, and one other attorney. Like, Tip had 4 attorneys in federal court fighting for him to come out. And ultimately, got a good deal. Here we go.
Chris, you have to get some more tape. She's coming off. All right, ladies and gentlemen, we got to take up some other things. And so what I want to do at this point in time is go ahead and recess for the day. Okay. So, Mr. Bean. I need you to be here for 10 o'clock on Wednesday, March the 13th.
Yes, sir.
10 o'clock, Wednesday, March the 13th. You good with that?
Yes, sir.
Okay.
What?
As I mentioned earlier, don't discuss your testimony to anybody except the attorneys in this case, okay?
All right, 10 o'clock. Yes, sir.
All right, we'll see you then, okay?
Yes, sir.
Okay.
March 13th. What the heck? Wow. Wednesday, March 13th.
Okay. All right, ladies and gentlemen, jury, let me go ahead and take up a couple of things with you. Okay, as you know, we are going to be in recess tomorrow through next Tuesday. So that's the 5th through the 12th. So we good for that? Okay, now, I've shared with counsel that I'm in receipt of some correspondence from you about that you've taken an unscientific poll amongst yourselves, not in violation of the court's admonitions, but to ask about spring break and parentage and other things. Is that right? Don't be bashful now. Come on now. I got paper, okay? So have a good faith basis asking of this, all right? So is that your desire between the 1st and the 5th of April to be down? I think a majority of you wish for that to occur?
Yes.
Okay, all right. I've talked with our lawyers, and I think that would be appropriate, okay? So I wanted to address it to you now because I know you all want to plan, all right? But don't ask me for nothing else, okay? Nothing. Okay, all right, as long as we're good with that, okay? No, I'll do it, and I think it's appropriate for you all to be able to spend that time with your for those of you that have school age children and the like. So we will be taking up other matters during that particular period of time. Okay, fair enough. All right. There's another person that sent me a note talking about the 20th of March. Don't identify yourself, okay? But I feel on pretty good authority that particular morning, you will be able to make that appointment that you need to make. But I've told all of you, please make your appointments I think I give you enough time so that we don't have any, kind of discrepancies with this as much as we can do it. Okay. So, try as much as you can. I mean, I know life happens and we'll flex on that and we appreciate that. But to the extent that you can, make your appointments or on the other days that will be kind of down or have administrative time, please go ahead and do so, okay? So, huh?
In recent, a couple of us have been getting some pushback, even though you have been giving us notice.
Pushback from who?
The doctor's office. Some of them are booking out like 8 weeks out.
I understand that, and we'll work with you, okay? I understand that. I'm giving you a hard time, but but to the extent that you can, please do so. But we'll do whatever we can with that, okay? But if you can, what I'd rather you do, if you do have an appointment, make it first thing in the morning or as late as you can in the afternoon, so we can go ahead and take some. I can release you early or have you come in late, okay? So to the extent you can, I mean, as I tell people all the time, life happens and then you do your various vocation. So we'll do what we can for that, all right? Okay? All right. So do I have any other ministerial inquiries of me at this point in time? Now that I've addressed the spring break and other appointments, and we'll just, like I said, we'll deal with them as best we can, okay? All right. Anybody else have any other inquiry, question? You sure? All right. Okay.
What about a bond
Ladies and
motion?
gentlemen, unless you have anything else of me, what I'll do is at this point in time, I'll give you the customary ad nauseum admonitions for the period of time that we'll be down. And that is leave your notepads in the basket. Go ahead and take a juror sticker so you can take one and have one. Please do not discuss anything else that you've heard about the case amongst yourselves as you are going, no matter where you're going and who you're with, small groups, ones, twos, at home, at any other place you may find yourselves. It would be a violation for you to do so, okay? The other thing, ladies and gentlemen, is please do not consult any outside sources, books, the internet, or any other reference materials. Do not go by and visit the scene anytime or involving anything that we may have talked about here in open court. And remember, the only thing you can lawfully consider is what's presented to you in the four walls of this courtroom, all right? So with that, and also if anybody, as you know, tries to discuss this case in your presence or hearing or approaches you, you need to let myself or Deputy Ingram know immediately. And also please resist the temptation of listening to any news reports, podcasts, or any other third-party sources that may reference or chronicle this trial in any way, because remember, the only things that you can take up or consider are what is presented within this courtroom. So I know that the temptation is great. Well, let's see what the lawyers and the judge are doing. No, that would be a violation. And remember, I told you that the way, how do we find out about these things? Y'all tell on yourselves. Yeah, you squeal on yourselves or you squeal on one another. So let's not do that. You all have been really good. So just continue to follow my admonitions, okay? All right. Do you have anything else, ladies and gentlemen, of me?
Are we supposed to report at 10 on the 13th as well?
Yes, ma'am. At 10 o'clock. Yes, 10 o'clock for 10 o'clock on the 13th of March. That was the first question. I saw another couple hands go up. Sir,
Same question.
anybody else? All right, you sure? Okay, all right. All right, ladies and gentlemen, then we will see you all next Wednesday at 1000 hours, and we'll see where the day leads us at that point in time, okay? All right, we're in recess. All right, ladies and gentlemen. Okay, ladies and gentlemen, please be seated. Our jury has left us. Councils, I will include, or you're welcome to take a look at these notes. I'm just not going to make them for public discernment. I will seal them in reference to our jury that has a doctor's appointment, as well as the unscientific poll that the jurors have taken. Okay, so you're welcome to take a look at them. I'm going to give those to Ms. Weaver, and they'll be sealed for purpose of record. Okay. The other thing, ladies and gentlemen, as I mentioned earlier, and we'll talk about it a little bit later, but the first of, and I had a bench conference with representatives from the state, Ms. Love, and also Mr. Steele and Mr. Matthews in regards to that week that the jurors are going to be down for those, their children that are in Atlanta system, Fulton County system, as well as that particular week of starting the 1st of April. It's the court's pleasure for us to take up Monday the 1st and or Tuesday the 2nd, any outstanding motions that may be had at that point in time. So block your calendars for 1 April, 2 April, that's Monday and Tuesday. And the court is going to give you a little bit of a administrative pause for the rest of the week, okay? But to the extent that we can, I know Mr. Steele's got a couple of motions that I need to take up at that point as well. So, all right. Any questions of me? Anyone? All right. Okay, so folks,
Interesting.
all right, as to the ministerial, as to the scheduling. Okay. Since our jury has left us and it's advocates and clients and the court. The last thing that we were talking about at the bench was in reference to conversations that were supposedly made by Mr. Bean at the hospital. And I believe that we are in disagreement as to a couple of things. One, whether or not the statement was made referencing an event at the hospital. So I want to say that in order to seek ground zero on that, we'll have to let Ms. Weaver prepare or at least the transcript in reference to the testimony of Detective Velasquez in regards to his testimony on this particular statement made by Mr. Bean's statements. Okay, that also may have to be cross-referenced along with the interview of Mr. Bean, as well as the purported statements that were made to Mr. Steele and his investigator. So, councils, I'm going to let you all kind of take a look at those three sources and be prepared to kind of talk about those when we come back on the 13th to see whether or not, in fact, that is, if we've been able to find some particular granularity on those particular statements and in terms of whether or not this particular conversation was had at the hospital or not.
Your Honor. And Your Honor, I have, if we will address this on the 13th, we can do that. I will be presenting to the court the statements that were made by Detective Lewis, and of course, we'll wait.
Detective who?
Well, Detective Lewis stated that when she went to the hospital, there were 2 males there.
Okay, so we'll need her testimony as well.
Right. I can give the court the statement that she gave.
Oh, I'll the statement or the transcript, the testimony.
She has not testified yet.
Okay,
She has not testified, but Detective Velasquez
referenced her
going to speak to Frederick Prothro and Walter Murphy. And then after she came back to the homicide office, after she came back from speaking with Murphy and Prothro, when talking to Brian Taylor Ransom, they learned that the car had been loaned out to Adrian Bean. So on scene, they did not know what, if anything, Adrian Bean had to do with the incident that occurred over in Summerdale. And Adrian Bean.
Okay, but the issue we're trying to create granularity on is whether or not Mr. Bean was taken to the hospital, whether or not he made statements from the hospital. That's what the genesis of you all's discussion is, or was it up here at the bench?
That's right.
So can we focus on that? That's what you objected to, because you said there's no basis for him. And Mr. Steele said, well, this is what he told me in the taped interview I had with who's your investigator again? Mr. James Martin Jr. So that's what the contention is.
That's the base, and that is the basis for the objection, because Adrian Bean never went to the hospital, and I was only.
Okay, well, he might have lied. I mean,
to them, yes.
Yeah, I mean, and that might be the truth. I mean, he lied about it. So, but whether or not that happened or not, I mean, I want you all to, I mean, I know Mr. Steele wants to know whether or not that is true or not, because he certainly doesn't want to present any untrue testimony to the tribunal. But if he has another good faith basis that he was actually at the hospital, that's what I want you all to find out.
Yes,
Mr. Steele, I think you need to find that out, sir. Whether or not he did, in fact, because you can't also, I know you would never do this. You cannot tell a witness something that you know is not true either. So, and I know you wouldn't do that, but I think issue, let's just find out.
Why even imply that?
You know, I mean, there's any number, a couple scenarios that might have occurred in this situation. So I'll let you all figure them out.
Like he lied, like maybe still said something that wasn't true, or maybe the prosecution witness is bogus.
All right. Do either counsel want to add anything about the conversation we had at the bench in reference to our administrative pause in terms of our jury? You didn't know what I was talking about, right? No. I was asking Ms. Love about, do you want to add anything in reference to our conversation up here at the bench about the administrative pause?
No, Your Honor.
Okay.
We're just fine with that.
All right. Okay. All right. Okay. Any other ministerial or any other things I need to take up?
No.
Okay. All right. So you all figure that out, and then I'll take it from there on the 13th in regards to Mr. Bean's statement. Okay.
Yes, Your Honor.
All right, okay, unless there's anything else, councils, we'll see you all on the 13th of March at 10 o'clock, okay? All right, we're in recess. All right.
There you have it, ladies and gentlemen. There you have it. This case is going to last a very long time, as you can see. And now we have another break. Another break. Not only this break, but there's going to be a spring break after they have this break. Oh my goodness. And I go back and think about the other trial, the Nature Boy trial, where the judge could have just had a couple of days break so you know, so she can test positive. I mean, not test positive, test negative, because we still don't know whether or not that test she tested, because it was never shared with the people in the court. So I don't know. Right? He's just sitting there, like he's literally just sitting there without a bond. I should tell you something, ladies and gentlemen. I should tell you something. Right now, he's sitting there without a bond. He's not accused of murdering anyone, but he's sitting there without a bond. Just let that sink in. If you know the case is going to last this long, why drag the man? He still has a presumption of innocence. Why drag him for that matter? Or any other defendants that don't, there's not a danger to be on the street. But why drag him? That is the question. This guy has to pay his lawyers. He obviously has to pay for, things that he had pending before he came to this courtroom. So yeah, give the guy a bond, give him a reasonable bond, let him do what he does. Like ASAP Rocky, he's on bond. He's able to go to work and make money and be able to pay for his lawyers. He doesn't he can't write this off. Can't write all this off. It's just crazy. Yeah, Beam is like a piece of work. Piece of work. You look at his rap sheet. Guns, 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 guns. Guns, guns. Probation, jail time. He said, he's a problem. I don't know. Even just watching him on the stand, I don't know. Maybe he's changed his life. I don't know. But you're 42 years old and you're still on probation. It's like kind of crazy. 44. Hey, stand by. Stop. Sorry about that, ladies and gentlemen. Sorry about that. Hold on, hold on, hold on, hold on. Hold on, hold on. Hold on. Okay. Well, there you have it. We are in recess. Ladies and gentlemen, we are in recess. And thank you for guys. I appreciate you guys coming in, being a part of this live. You could have been anywhere, but you chose to be here. With that said, while they're coming back the 13th, we'll be back tomorrow covering another case and another one and another one. With that said, I appreciate everyone being here. Thank you for all the love that you've shown today, as you do. It may be over for them for the short term, but we got to be back here. We got to be back here. We got to do this thing again. But with that said, we're going to take you guys out of here. Let's see how we want to take you guys out of here. Let's see here. We're going to take you. No, we're not going to use that. We're just out of here. Thank you, guys. I appreciate you. 1, 2.
to the beat. Let's go. Just kidding.
No hip hop today. No hip hop today. No rapping. No rapping, ladies and gentlemen. I don't know. I don't know. I can't even answer that. I really can't. But with that said, ladies and gentlemen, I appreciate you. I really do. We'll see you guys next time. Let's see you next time. Just make sure you follow all our social media pages and make sure you like and subscribe to the channel. With that said, ladies and gentlemen, thank you. We out.